Judiciary Committee to order, and if you can all rise and please follow with the Pledge of Allegiance. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, we're going to open up the hearing on CACR 6, and I recognize the prime sponsor, Representative Keith Amon.
Good morning, Mr. Chair, and wise members of the Judiciary Committee. For the record, my name is Keith Amon. I represent Hillsborough District 42, which is the towns of New Boston, Mount Vernon, and Lineborough. So I stand before you as the prime sponsor of CACR 6. It's a constitutional amendment that recognizes the right of individuals to use computation resources as a fundamental right. And this might seem like a novel concept, and I admit that it is maybe the first try at something new. So as we're gathered today, we're living in a world where computing has become an essential part of our daily lives. From communication and education to economic opportunities and personal expression, computing has revolutionized the way we live, work, and interact with one another. I think that's indisputable. However, as our reliance on computing grows, so do potential threats to our ability to access and utilize those resources. And we've seen instances of governments and corporations imposing restrictions on internet use, censoring online content, and exploiting personal data for their own gain. I passed out copies of an article from the website MoFo, and it stands for Morrison Foley, I think.
Okay.
I just thought that was kind of funny.
Thank you.
And it's an article about an executive order that President Biden signed in 2023, and this is the precedent that has been set by the federal level that we need, I think, to consider ways to combat, and that's what CACR 6 is designed to do. And you can read the details in the article I passed out. It basically required the registration of AI models over a certain level of computation, a certain number of parameters. So it required you to register your AI. It was since rescinded January 21st this year, when President Trump, on his second day, he rescinded that executive order. But the precedent has been set, the challenge has been set, that computational resources would need to be registered with the government. So I'm thinking about this similar to the fundamental right of the freedom of speech, the freedom of conscience, the freedom of the press, and maybe even the Second Amendment, because using computation allows you to, be more successful. It enhances your thought processes, and I think as time goes on, we're going to see that become more and more true, and more essential for our survival and our liberty. So look at that executive order, the article about that executive order. I urge you to consider that. So the executive order raised significant concerns about the potential for government control over AI development and deployment. It also sparked debates about the balance between innovation and regulation in the tech industry. And as policymakers, it's our responsibility to ensure that any regulations or laws related to computing are fair, transparent, respectful of individual rights. And that's why I think it's essential that we take a proactive step to protect the rights of the citizens in the digital age. CACR 6 aims to do just that by establishing the right to compute as a fundamental right protected by the state constitution if it were adopted. So in closing, I urge you to consider this, I urge you to think about it and consider the need, the potential need for this as a protected right enshrined in our Constitution. And with that, I'll be happy to take any questions.
Questions? Representative McFarland?
Thank you, Representative Ammon. My first question is with regard to the wording of the article. I noticed that you don't speak to encryption. What are your thoughts on a possible amendment to the article that is proposed here that would address that as part of this right?
That's a very good question. Because encryption necessarily involves computation, whether you're doing a math problem on a piece of paper or using high-level computation to really firmly encrypt something. I think it's sort of implied.
Follow up?
Follow up.
So while I would tend to agree with you in my interpretation, I imagine that there would be a lot of other interpretations. Do you think that changing the language in that way would make it less likely to pass?
I don't know. I'd have to see the language. It should be simple, clear, and easy to understand. That's because it's going out to the citizens of New Hampshire to vote on. So that would be my desire, is that if you have an amendment, that it's simple and clear.
Thank you.
Representative Turer?
Thank you, Mr. Chair. Thank you for taking the question. Building on or similar to what Representative McFarland just asked, I read, it's obviously there's only 2 sentences to this. So when I read the first sentence, the right of individuals to freely access, use, and employ computation resources, including devices and networks essential to computation, shall not be infringed. That to me sounds like it could interfere with all forms of security, not just encryption, but all sorts of authentication, access to private networks, to public networks. I agree with your basic premise that our lives are hugely dependent on computational resources, and restricting them could have severe consequences. But the language here worries me. I see the next sentence says discriminatory, but I'm not really sure how discriminatory would in any way limit what the first sentence says. Could you say a little bit more about your thinking there?
Yeah, thank you for the question. Just like the freedom of the press, right? It doesn't demand that you have access to all the presses or be provided a press, right? It's the ability to express yourself using, the press was a machine that pressed copy onto paper, right? That was what a press was. The computer is just a more complicated version of that, and a less materialized version of that. And so, similar to freedom of the press, this would be the freedom to use computational resources. It doesn't mean that you can impose yourself on other people's resources. And computation with encryption, it creates barriers that prevent you. You'd have to defy the laws of physics, maybe, to break encryption, to access someone else's private information that's protected by encryption. So I think the right sort of balances itself out if you really think about it.
Representative Smith?
Thank you very much. I'm a Luddite, and to me, computation is addition, subtraction, multiplication.
Yeah, that's the foundation of it.
And after that, I'm on very thin ice.
Mm-hmm.
But I'm thinking about a number of bills that we have had this term that deal with abuses against children. And those bills generate not just neutral academic response, but certainly emotional response. And I understand that confuses things. But if I read this, if someone has been involved, for example, in child pornography,
It's a very serious thing that you're bringing up.
yes,
Yeah.
and if they have been convicted,
Mm-hmm.
and if there's been an attempt in the best interests of the people of the state to protect the rest of us from public from this individual having access to child
So
pornography.
you're talking about using computation in the commission of a crime, a very serious crime in this case, but abusing a right. Rights don't have, the rights aren't unlimited, right? And if you look at the language of the amendment, it covers the scenario that you're describing.
Help me see where, Representative.
Would you read the first sentence for me?
Freely access, use, and employ computation resources, devices and networks essential for computation shall not be infringed. No law or regulation shall impose discriminatory rates, restrictions, or limitations that unreasonably burden that right.
Right. So unreasonably would be one of the qualifiers in that. So just like we have the First Amendment right, the right to bear arms. But
That's
if we go
not the
around,
First Amendment, even I know
second
that.
Amendment. I do know that. But we don't have a right to go around shooting people willy-nilly, right? That would be abusing that right, and therefore we don't deserve it in that case. So it would be the same standard would apply to this potential right.
Thank you.
Okay, thank you.
Representative Horrigan?
Yes, these AI and then other emerging technologies that I know you're personally interested in, like Bitcoin and blockchain, they use an immense amount of electricity, and often the servers, there's a lot of externalities associated with the servers because they, aside from using electricity, they often generate heat and noise. And, there's been some, so does this interfere with the state's, responsibility to, conserve energy and manage the power grid and just make sure the infrastructure operates fairly for everyone involved, and that these AI servers and whatnot don't monopolize the power supply to the detriment of other uses of the power supply?
Could you explain that question?
Yes, well, we've had a lot of problems. Well, certainly with Bitcoin, there was when it came in, there were a lot of small entrepreneurs who would set up these Bitcoin centers in various remote places near hydropower, which would often create problems for the neighbors. And then on a larger thing with the AI, like Google, for example, I believe it was, now I forget which, Google or one of the other major players, for example, is going to reopen the 3 Mile Island nuclear plant and build a huge AI farm around it. So that's obviously there's a lot of electricity, a lot of power being used on that, and then doesn't the state have some responsibility to at least keep that in check, so that one particular segment of the economy doesn't crowd out everything else in the economy and use up all the available energy supply?
I guess I don't have that same fear that it's going to eat up the whole economy. That seems kind of far-fetched, just in my opinion. We're talking about a national security issue when you talk about AI, building AI data centers. If our government slows down the advancement of AI in this country, do you think China's going to do the same thing? Do you think Russia's going to do the same thing? So we're in a very large and fast competition right now, and it has to do with providing efficient compute and feeding it with energy, and so that these AI models can be trained and get smarter and bigger. So I just don't see that it's going to eat up the economy. I think it's a tool that's very useful that we should encourage.
China will definitely do the same thing. Russia seems to be a society in decline. I'm not sure. But anyway, thanks for your answer.
All right, thank you.
Representative Manos?
Thank you, Mr. Chair, and thank you for taking my question. I don't have the article you were referring to, so I'm wondering if you could specify what your concerns were with President Biden's executive order.
I don't have it I don't have what I passed out all the copies that I was able to print. Okay, so I'm just going to go off of memory. It's the first time that the government, the federal government, demanded that if you have powerful computation, that you have to register that with the government. You have to regularly report on it to the government, as if it's a dangerous nuclear weapon. That's the way they treated it, as if it was fissile material that could give us all radiation poisoning. It's a computer. It's a big computer. But it's the first time that's ever happened. And so the precedent has been set. It's true that it was rescinded, but only because an election was won, right? If the election went the other way, that order would still be in effect today. So I think it's incumbent on us as a state with our own constitution enshrining rights into it, that we can consider that this might be a right that we should enshrine, because it's only going to get more embedded into our way of life. Like our expression is only going to, it's going to be amplified through computation more and more. And so it should be considered an extension of our thought process and our conscience. So in my view, I mean, I'm presenting this as a potential idea. So thank you.
You have a follow-up?
Thank you. I wasn't really, I haven't read I now have the article, but I haven't read it. But could you be a little more specific about what you were talking about, you mentioned, I think, registering, you mentioned two words, registering and something else that was required. Could you
Regular
be more
reporting, so that it was the Secretary of Commerce was empowered to make sure that they had the whole industry registered. So if your AI compute model was a certain size, and it's in the executive order, certain level of computation, certain number of parameters for your large language model, if it met that threshold, then you had to register your model with the government and regularly report on your activity and sort of explain yourself, on a certain metrics on what you were doing, how you were training it, and all these other things. So it's the first time it's happened. I'm just saying, like, maybe we want to push back against that precedent. So thank you.
Do you think that might limit or stymie people that want to do this work, that might say, maybe I'll stay out of it? Or is it going to limit our ability to compete if we have to register these things?
It potentially could. I mean, I don't know if you saw what Europe is doing, it's like only in the last day or two. They're putting a bunch of money towards AI, but they're also completely micromanaging it, right? And I think in that environment, it would stifle our ability to compete. And it also concentrates power into the hands of a few corporations that have the lawyers and the technical know-how, right? It stifles the startups, and the next potential big idea could be stifled. So,
Representative McFarland, you had one, and then.
Thank you, Mr. Chairman. Would you agree that for those people who might be looking at this constitutional amendment and saying, why now, why in this state, why is this not an issue for somebody else or an issue at the federal level, that we here in this committee received testimony, as Representative Smith was alluding to a week ago, on House Bill 293, which is legislation that intends to prevent minors from accessing obscenity, but actually acts to restrict people's ability to compute. Would you agree that this is a present issue, not only nationally and internationally, but in this state, and that we already have, in the example of Article 2A, where there's a broad constitutional protection for the right to keep and bear arms, we still have reasonable legislation, and some might even say overburdensome legislation that has been upheld by the courts?
Based on my understanding of what you just described, I do agree with that. Yeah.
Thanks.
Representative Turer?
Yeah, thank you. Thanks for taking another question.
Yeah.
So, quick read of this article that you handed out. It's focused on registration and reporting, not passing judgment on whether that's good or not. How does that cross over to the constitutional amendment that you are proposing, which really doesn't seem to impact the idea of registration and reporting, but seems to imply a leap to some form of restriction that I don't see in this executive order, or maybe the flip side. Why didn't you target this directly rather than the way that this is worded?
It's a broadly stated right. So my question, I guess, if I could ask you a question in return, if I was developing a large AI model and I didn't comply with registering it or reporting on it, what would happen to me and my company and, my resources, right? There's always an or else whenever there's a demand for reporting and, registration. So that would be my response, is it's the or else that we're pushing back against.
Yeah, and again, just sorry, follow up, because you did ask. I think what I'm saying is registration and aggregate reporting of your activities. I mean, if those are in place, not passing judgment, good or not, good or bad, if that's the law, then every organization has to comply with it.
It's not, it was an executive order, but
executive order. Okay. Yes. We're all familiar with those these days. The leap between that versus what this implies, which is that somehow that is going to restrict, this is an individual right, not a sort of collective right. It doesn't sort of say how this would be, prosecuted or enforced. So I guess that is, not to belabor this, but, how do you make the leap between a reporting requirement to, discriminatory prevention of access to computer systems?
I guess the gun owner in me would say, if I had to register my guns with the government, I'd probably have a problem with that, right? So it's sort of a similar, or if I had a printing press and I had to register that printing press with the government, I'd have a similar reaction, right? Like, it's it may not be overly burdensome, but it's still an invasion of my right by having to report on myself to the government, right? That's kind of my gut reaction to that.
Any other questions? Seeing none, thank you.
Thank you very much.
Sarah Scott?
Thank you, Mr. Chair and members of the committee, for the opportunity to testify here today. My name is Sarah Scott, and I'm the Deputy State Director for Americans for Prosperity here in New Hampshire. And on behalf of our activists across the state, we are here in support of this legislation, which seeks to enshrine the right to compute in the state's constitution. So we support this amendment because we believe in the transformative capability of artificial intelligence and emerging technologies. We believe that technology can meet its fullest potential when the government is doing its part to get out of the way and not wrap emerging technologies in red tape. Innovation in computing, artificial intelligence, and digital technologies is advancing rapidly. Yet there's a growing concern that overregulation could limit access to computational resources, stifle innovation, and restrict individual autonomy in the digital space. Some policymakers across the country are seeking to impose sweeping restrictions on computing tools, which could hinder economic growth, personal freedoms, and competitive edge in technology. Businesses are watching the landscape very closely right now, and tech firms need predictability in the laws that govern their industry. A constitutional amendment provides the highest level of protection, ensuring these companies and individuals won't face sudden restrictive legislation that forces them to leave the state. In an increasingly digital world, access to and the ability to utilize computing resources are no longer luxuries, but necessities. And this constitutional amendment recognizes that the basic access to computation is essential for participation in modern society, from education to employment, to civic engagement and communication. Similar to how we protect the rights to free speech and assembly, we must also protect the right to compute and ensure that all individuals have access to utilize the digital tools they need to thrive. This amendment is really just focused on affirming the fundamental principle that individuals should not be arbitrarily denied access to computational resources necessary for full participation in the 21st century. So it's for these reasons that we ask you to support this amendment. Happy to take questions.
Representative Horrigan?
I apologize. I was taking a phone call when you started. So what is your name? What's the name of the organization you're representing, and who is that organization again?
My name is Sarah Scott, and I'm with Americans for Prosperity.
American for Prosperity. Okay, yes, I'm familiar with them, so I know where they're. Okay, I get it. Thanks.
Representative Tripp?
Thank you. Thank you for taking my question. Since this is going to become a right, does that mean that the like the state of New Hampshire has to provide the internet access, the computers, the whatever else is needed for computation?
I would view this as similar to some of the things that Representative Ammon brought up, like the First Amendment, for example. We tell people they have a First Amendment right. We don't tell them that they have a right to access that. Same with the Second Amendment. I can't walk into the store and say, because I have a Second Amendment right, you have to give me the gun for free. So I view this in a similar manner.
Thank you.
Representative McFarland?
Thank you, Mr. Chairman, and thank you for your testimony. So I think in a similar fashion to my question to Representative Ammon, I would ask you and your organization, do you believe that the language of this proposed constitutional amendment is sufficiently broad? And do you think it would help or hurt this legislation to be more explicit around encryption?
So I think, thank you for the question. And I think that when you're looking at encryption, that's obviously a very complicated issue. I think it's important to address it, and I wouldn't be opposed to adding it to this legislation. But I think that when an issue, especially a constitutional amendment, becomes too complicated, and technology is moving so quickly right now that it's increasingly difficult to keep up, and that's for those of us that are paying attention. So when you look at the average voter, I don't know that they'll have sufficient understanding to incorporate that into this language, but I do think that it's important to address, so I wouldn't be opposed to it either.
Follow up.
That being the case, if we contemplate that this goes forward more or less as written, and you hypothetically envision this being enacted into our Constitution and then contemplated by the courts, we've seen fairly coercive and stringent regulation on other constitutional rights, quote unquote. How do you perceive that we might better protect this right if we were to enact it?
Just to clarify, protect the right for computation or encryption?
No, the general right to compute.
I think, as you've seen with when we passed the constitutional amendment a few years ago on digital privacy, the right to privacy, we've seen court cases and legislation now being proposed to really solidify that right. So I would envision probably a similar scenario, especially with computation. What is happening today is going to be very different than what's happening 6 months to a year from now. And so I don't think we can accurately predict the extent to which where the industry is going to move. So I think there will be further legislation that will likely be needed. But I think what this amendment does is really solidify the idea that in New Hampshire, we're a state that you can come in and we're willing to work with you to figure out how to best allow you to pursue in this technology. I think that this really sets us apart as the beacon for the movement overall. There are other states that are looking at similar legislation to this year. There are also states that are looking at regulating it. And so I think that New Hampshire has been at the forefront of a lot of these arguments in the past, and I think continuing to solidify our position as a state that is welcoming to the industry would be a huge benefit to the economy here as well.
Thank you.
Any other questions? Representative Manos?
Thank you, Mr. Chair, and thank you for taking my question. I don't remember the term for it, but the concept that, for example, Comcast or Xfinity can slow down your internet connection to be able to accommodate traffic or for whatever purpose they're doing that. It seems to me that as I read this proposed constitutional amendment, it would prohibit that. And I'm just wondering whether you have a view on that.
Thank you for the question. I admittedly do not know enough about how, I know Xfinity does it because I experience it, but I don't know enough about the legalities around that situation to really speak to it with this. But I can try to get an answer from somebody who would speak to that.
Thank you. Any other questions? Seeing none, thank you. That's the last pink card I have for this bill. Is there anyone else here that wishes to speak on it? Seeing none, I'll close the hearing on CACR 6. And we still have a few minutes here before the next one. Whether we have enough to. It's officially 10:15. I'm going to open the hearing on House Bill 615 and recognize the prime sponsor, Representative Dan McGuire.
Thank you, Mr. Chairman and members of the committee. I lost my voice the other day from the political problem of speaking too much, so I'm going to try to be brief. This bill is a fairly substantial rewrite of RSA 318B:17B, otherwise known as forfeiture of items used in connection with drug offenses. I apologize for the length of the bill. Part of it is just this whole section is lengthy, and part of it is that this is all about courtroom procedure, and in our discussions with the judiciary, they like length. They like a lot of specificity, and so that kind of has made its way into the bill. The goal of the bill is twofold. One is sort of greater fairness in these kind of cases, and I'll describe what these cases are, but also efficiency in the courtroom process. So what these cases are is that they deal with the situation where someone is arrested for possession or sale of drugs, and property is seized along with the drugs, and that property can be forfeit if it's used in connection with selling drugs. So, for example, somebody selling drugs out of their car, the car can be forfeited as kind of an instrument of the crime. More typically, that's one typical example, but also somebody is arrested and next to them is the drugs and a bag of cash, right? So the cash is often forfeited as kind of the fruits of the crime. And so this section of law deals with how those court cases go, and sort of traditionally, or the way it's written now, there's almost a separate case involving the property than the case involving the crime. So the criminal case is currently, it's prosecuted typically in superior court. You get a criminal defense attorney when you're accused of such a crime, and so on. But the case against the property is only a civil case, and it's prosecuted by the Attorney General's office. So often these criminal cases are prosecuted by the county prosecutor, or in case of Manchester, city prosecutor, that kind of thing. And the case against the property, against the bag of cash or the whatever, is a separate case prosecuted by the Attorney General. Now, we do already have in law that the property is not subject to forfeiture if the person is not convicted of the crime. But the problem is, because these are separate cases in separate courts, different judges often, different prosecutors, and no criminal, no defense attorney provided for indigent defendants, essentially most of the time these cases are just there's no contest, right? They're just decided by default, right? So the person doesn't bother to put up a defense of their property. Obviously, they have the normal criminal defense of themselves. And so what this bill does is it merges the whole procedure so that it effectively becomes a single procedure, and the criminal case would tend to go forward first, and then the action against the property would happen at the end, typically, and be kind of just part of the penalty part of the crime. So if, assuming someone's convicted of the crime, then the property would be forfeit, or and so on. So the main thing is that the case would go into the exact same courtroom with the same prosecutor, with the same defense attorney, everybody would be on the same page, basically. And so that's the efficiency part, right? So you don't have to have two cases, two judges, and all that kind of thing. And we look at it as this would be the part about the property would just be a very minor sort of thing at the end. Now, as far as fairness goes, that's also having that better procedure creates more fairness, because the defense attorney who would be there to defend the property as well as defending the person accused of the crime. And so there would be many fewer defaults. It would be the case that the property aspect would be held off till later. The criminal aspect would go first, assuming if someone's found innocent of the crime, that would be the end of it. If someone's found guilty, then that attorney would be there for another few minutes dealing with the property thing. But there wouldn't be defaults, which are basically unfair. The bill also does a little bit in terms of putting in minimums of property. So if it's currency, the bill puts in a minimum of $1,000, and a vehicle at $5,000 value. So you won't be seizing and trying to sell cheap, really stuff, property that's not worth much, basically. And it also increases fairness for innocent owners. So what can often happen is you borrow somebody else's car, you borrow your mother's car, you borrow your wife's car or something like that, and you say, I'm going to the grocery store, and then you're arrested in the parking lot selling drugs or something like that. So the bill has ways for the innocent owner who didn't realize that their car was going to be used in that way to get their property back in a more expedited way. So the other thing I handed out, by the way, so this bill had previously gone. This is a subject of legislation for long periods of time, and the one that we had 2 years ago went to the Criminal Justice Committee. They turned it into a study. I handed you out the results of that study. The bill has changed a little, but the main things is we removed from that particular version of the bill the things that were most objectionable to law enforcement, and we made it so that what's left is all courtroom procedure. So the bill doesn't change anything to do with what gets seized, how it gets seized, anything to do with law enforcement, what happens to the funds that result, all that sort of stuff is unchanged from current law. The bill itself is all about what happens in court. And I'm happy to take questions.
Are there any questions? Representative Smith?
Thank you. Good morning. In a case in which the accused is represented by the public defender, it's a criminal case, would, under current law and practice, the public defender also be permitted to represent the accused in the issues relating to forfeiture rather than the original crime?
Yes, thank you for the question, Representative. I'm pretty sure the answer is no, that the public defender does not handle civil cases.
Representative Manos?
Thank you for taking my question. I was going to ask the same question that Representative Smith asked, but I'll just broaden it a little bit. An indigent defendant has a constitutional right to counsel in a criminal case. the indigent defendant does not, or I'll ask it as a question, does the indigent defendant in the civil forfeiture case have either a constitutional or a statutory right to the appointment of counsel?
So thank you for the question, but realizing I am not an attorney myself, right? But my understanding of it, having dealt with this for a long period of time, is that the answer is no. That you only have the right to attorney if it's a criminal case, not if it's a civil case. And that's one of the problems. I mean, that's one of the most serious problems that this bill is trying to address. Because in my mind, it's not really a civil case. The way we wrote this bill, by the way, originally was to make the entire procedure a criminal case and make the forfeiture just part of the penalty of the criminal case. So one case instead of two. The problem is we met with the judiciary at length, and their computer system couldn't handle that. It would have cost them a fair amount of money to make the changes to their computer system to make that work. So we ended up sort of keeping the two cases, but they worked out a way of sort of linking those two cases. So there'll still be a civil case, but it'll have sort of different burdens of proof and things like that, that all those kind of details are in the bill, but those cases are linked, and it's sort of helped the judiciary be able to deal with this, to actually make it more efficient for them without any cost, right? Without any serious cost to them.
Follow up?
So there would be an additional cost to the state for the public defender or counsel to represent the indigent defendant in both cases, correct?
Yes. So yes, but so in my opinion, we're talking about 2 more minutes or something like that, right? I mean, you get to the end of the criminal case and you say, okay, he's guilty. What's happening to the property? It's going to be forfeited. You know what I mean? It's a very short thing. It's not like it's a completely separate case situation and all that sort of stuff. But it's also in less state expense, because right now there are people at the Attorney General's office who all they do is these kind of civil cases, right? So all they do is this, whereas if you combine it with the criminal case, the county attorney, again, another 2 minutes, can deal with both. So,
Representative Alexander?
Thank you, Mr. Chair. Thank you for taking my question. My question was on your proposed amendment. The third change is regarding somebody else who owns the property, but it's used in a crime. The language of actual knowledge is confusing for me. I know you define it, but I guess I'm wondering who has to prove that they had actual knowledge. Is it the government, or is it the individual has to prove that they did not have actual knowledge of the crime in order to get their property back? I guess I'm wondering, like, who bears that responsibility?
yes, thank you for the question. So you brought up the amendment. So let me just give you some information about that. So your chairman, Representative Lynn, and other attorneys who are helping us with this legislation got together and went through this bill in a lot of detail. And these were the changes that Representative Lynn liked, and we were happy with too, to try to clarify stuff. And in this particular case, so the actual knowledge part is something that the court, it's the knowledge they would have to prove about the innocent owner, the owner of the property, the owner of the car or whatever, had knowledge that it was going to be used in the crime. But the burden of proof for that is not we think, too difficult for them to process. And there's an attorney here who will talk to this kind of level of detail better than I can. So
Yes, thank you. And I'm going to defer my question to an attorney on who has the burden of proof in that specific
thank
case.
you.
Thank you.
Representative Smith?
Thank you. I'm becoming more and more confused.
Oh, I'm sorry about that.
No, it's my fault, not yours. If I understood you correctly, you were trying to combine the criminal and the, in quotes, civil issues into one case. Yet the defendant, the accused, is to be permitted to have state-appointed legal counsel only for the criminal, not the civil. And if I understood you, the reason that you couldn't handle this in a more appropriate way is that the court claimed it did not have the money to help create a system that would be necessary. Am I missing something
Yes.
here?
So thank you for the question. Let me try to clarify. So the part about the court and the money, I'm not inclined to spend money when it's not necessary, right? So we worked out with the court an acceptable version that didn't require spending money, right? So that's that. The part about the attorney is the state can provide attorneys for indigent defendants in civil cases if they wanted to, right? I mean, but constitutionally, we have to provide attorneys for people in criminal cases that are indigent. But civil cases, we may or may not. It's up to us, right? Just like any other kind of law. So this bill says that in this particular little kind of civil case, the attorney will continue, the attorney who's been provided for the criminal part will continue on the civil part, if you see what I mean. So this is sort of adding that. But it's not something that's constitutionally required. It's just something we want to add.
Representative McFarland?
Thank you, Mr. Chairman. With regard to the language on line 23 of the bill that provides an exemption for lower value amounts of currency or vehicles.
What page is that?
Page 2, I think.
Page 2. Page 2, line 23. I would be interested to understand, first of all, how you arrived at those numbers. And second of all, if you would agree with me that those numbers are rather low.
Yes, thank you for the question. So I believe that those are sort of current practice in this area by the Attorney General's office. So this is just making explicit in law something that they're essentially already doing.
Follow up.
So if I understand correctly, one of the premises for the current practice of civil asset forfeiture in this state and in other states is to address things such as drug traffickers and others that are carrying excessive amounts of currency around that is entirely out with the normal circumstance. Whereas when I look at these numbers, I can readily envisage a circumstance where a tourist or a traveler may legitimately have well in excess of $1,000 on their person or in their vehicle and in their luggage. And I was wondering whether you think it might be reasonable to amend the bill to reflect a more appropriate number in today's society.
Yes, thank you for the question. But I think what you're thinking about is there are plenty of cases where when these are just civil matters, unscrupulous law enforcement in other states kind of target people traveling through, and there's plenty of cases like that, and don't even necessarily charge them with a crime, but they just charge the property with the crime, right? And so, but that's not going to be the case here, right? So the prosecutor in these kind of cases in New Hampshire, first of all, they have to convict them of a drug crime, right? So they're guilty of the drug crime, but they also have to connect the property with the crime. So if the defendant can say, yeah, I cash my paycheck and that's my $1,000, well, then that's not, the state won't be able to prove that this money came from drugs, right? But if the undercover cop bought drugs from the guy and marked the bills, and there are the bills, then it clearly is, right? So I'm not so worried about, yes, it's only $1,000, but there's some burden of proof there, and especially the key part is the person's guilty of the drug crime.
Thank you. Representative Tura?
Yeah, and actually my question builds on what Representative McFarland asked, and you may have partially answered it, but I want to check. That this clause, the minimum, seems to be one of the more compelling changes in the bill. I was going to ask if we have any statistics on what portion of civil forfeitures fall below those minimums, and sort of how much volume this might take out of the system. But did I understand that really there is no answer to that because we don't actually do that now?
Yeah, thank you for the question. So the whole business of reporting and what's going on now needs a lot of work. And the next bill you will be hearing addresses exactly that. So this is a good setup for that bill. But I would save your questions for that. Thank you.
Any other questions? Representative Manos?
Thank you, Mr. Chair, and thank you for taking my question. How does this fit in with the federal forfeiture law?
Yes, thank you for the question. So this does not affect the federal law in any way. My original legislation from 2 years ago would have, so it's essentially up to law enforcement and federal prosecutors to decide whether to prosecute these kind of cases under federal law or under state law. I mean, drugs are a crime either way, right? So they make a decision, and it tends to be the bigger cases or the cases that go across state boundary, of course, would be federal crimes, and some of the more minor stuff and the things that are 100% local would tend to be state crimes. But in general, law enforcement is allowed to sort of bring the case to whatever prosecutor they want, the federal prosecutor or the local one. And so my original bill tried to steer some of the more of the cases away from the federal prosecutor and into state court, because under this legislation, it's my opinion that the state procedures are superior to the ones in federal court. It becomes an adjunct to the criminal case. You have to have a criminal conviction before you can have asset forfeiture. You have the defendant available, the defense attorney available. All those kind of things make this situation in state court fairer than in federal court. But we decided, because this is a serious objection from law enforcement, they like the flexibility of choosing where cases get prosecuted. And so we decided we remove that from the bill. So the bill is strictly about what happens in state court. It doesn't control in any way where the case goes. That's the same process as it would be today.
Any other questions for this witness? Seeing none, thank you.
Thank you, Mr. Chairman. My other committee is meeting, so I will leave and come back.
All right,
if you
thank you.
don't mind.
Aaron Cregan?
Good morning, Erin Cregan, General Counsel for the Judicial Branch. Coming to discuss the engagement that we had with Representative McGuire, which was appreciate his great thoroughness on looking at all aspects of the bill and who it affects, and one of those people was us. Sometimes cases of different types are called at the same time. Probation violations can be called at the same time as the new charge, but they are still tracked by the court system in a particular way. It is not uncommon at all that for a bill that has a very important policy objective, there is a minor and ancillary court implementation concern that is not the primary issue in the bill, but potentially creates difficulties or costs for us. And we appreciate the opportunity to talk with Representative McGuire. We brought in our e-court people, we brought in our Superior Court people, and we think that this is the way that we can implement the bill without changing our case tracking system. So for us, the bill has likely no cost. We've had it looked at and we believe we can implement it. Ultimately, the policy determination about whether to pursue it is, of course, up to the legislature. But I do want to appear if anyone has questions about the court's ability to implement the bill.
Okay. So is it true, and this is a pretty lengthy bill, is it true that it just affects the court procedure and how it's handled and not necessarily law enforcement's involvement in it?
I would not want to speak for law enforcement. I see that they are present and potentially able to speak for themselves. But in terms of the court procedures, we have the ability to implement it. So for us, it is just a procedural change, and we can make that change.
Thank you. Anyone else? Seeing no other questions, thank you. Alessandra Whitney.
Good morning, Mr. Chair, members of the committee. Thank you for the opportunity to testify this morning. My name is Alistair Whitney, and I'm legislative counsel at the Institute for Justice. The Institute for Justice is a nonprofit public interest law firm that works around the country in both state houses and courthouses to protect people's private property rights. And we, as part of this work, have worked to reform civil asset forfeiture laws nationwide. We strongly encourage the committee to support this bill. This bill would make modest but incredibly meaningful changes to the civil asset forfeiture system in this state. The purpose of this bill is to protect property owners, importantly the innocent, and accord stronger due process rights to individuals facing the forfeiture proceedings. And also it is important for the purposes of judicial economy. I want to be clear, the way that this bill was designed means that civil asset forfeiture will still remain, but the important part of this bill is that it brings the civil asset forfeiture process in court under the umbrella of the criminal proceedings, meaning after a conviction in criminal court, the state may then seek the forfeiture of the property, the defendant's property. And we imagine this to be somewhat of a summary proceeding at the end of trial. It can be done at sentencing or at the court's discretion. It just needs to be after the defendant is found guilty. By doing it this way, the defendant will have the right to counsel in the civil forfeiture hearing because it is a part of the underlying criminal prosecution and trial. Right now, defendants do not have the right to counsel when they face the loss of property as a result of their criminal activity. We think that this is really important. We think that a defendant should have the right to counsel when they are stand to lose property, even if it is connected to criminal activity. And moreover, it will be efficient for the courts, I think, to handle these cases in this manner, right? Instead of 2 courtrooms, 2 judges, 2 prosecutors, possibly 2 attorneys, right? In 2 cases, we're essentially merging and marrying the civil forfeiture process into the criminal process. Another important part of this bill, finally, is that innocent owners will have the opportunity to petition the court and to let put everybody on notice that they did not have actual knowledge that their property was being connected to the alleged criminal activity. And this is one of the most important parts of the bill because it allows this body to fix one of the biggest problems that we have with civil asset forfeiture, and that is that it too often punishes completely innocent people. Imagine grandma, like Representative McGuire said, imagine grandma lends her grandson her 1996 Saturn Ion. It's a beater of a car, right? Unbeknownst to her, grandson is selling meth and using the vehicle to get around and sell meth, right? The car is seized because it is connected to an alleged criminal activity, and then it is subject to forfeiture, and grandma is out of luck. She's out of her car. That car may be only worth $1,000, $1,500 to her, or Kelly Blue Book value, but to her it may be worth a lot more. It helps her get to her appointments, to work, whatever, right? Under this bill, that car would no longer be subject to seizure and forfeiture, and if that car value was a little bit higher, if it was a newer car, then grandma would have opportunity to petition the court and to put everybody on notice that that is her vehicle and that she had no actual knowledge that it was being used in a criminal, for criminal activity.
Representative Alexander?
Finish first.
Okay.
Oh,
I thought he was finished.
Oh, I just have a few more points.
Oh,
I'm
sure.
happy to
I
take questions
apologize.
now. No, I'm happy
I
to
thought
take
you were
questions.
finished.
No, I apologize. As Representative McGuire said, and as been discussed earlier, this bill is a product of years and years of conversations, consensus, and compromise, and really an attempt to be very deferential to law enforcement's needs. This is not the sea change in law that I think some have made it out to be, and I want to tell you why. This bill does not really affect seizures of property. Law enforcement will still be able to seize property, subject, of course, to that $5,000 and $1,000 restriction on automobiles and currency, respectively. But money found near drugs are no longer presumptively forfeitable. Currency found near drugs no longer presumptively forfeitable. That is one change. The other is I'm sorry, and these are the exceptions to that. So, right, no roadside waivers, right? So we don't want to see the instance, and not alleging that it happens here all the time, but we've seen it in other places where law enforcement pulls somebody over and they say, hey, in exchange for not arresting you, you give me your car and I can let you walk because I see a bunch of cash in the backseat and I think that's connected to drugs. We don't want to see that happen. We will allow the defendant or the person to give up their property pursuant to a plea agreement signed on by the prosecuting authority and the state. But back to my original point, I think I was getting a little ahead of myself. This will really, beyond those exceptions, will not prevent law enforcement seizure of property for all intents and purposes, right? So they will still be able to seize property if it is suspected to be used as evidence in a criminal trial or criminal proceeding. If it has any kind of evidentiary value, in other words, right? Again, subject to some of those exceptions on the thresholds. And I also want to point out that while this is a big bill, yes, it really applies as it relates to the forfeiture proceedings to a remarkably small number of cases, but important that it still applies nonetheless. This applies to drug cases. This does not apply to every case. And as to the forfeiture proceeding and defendants' involvement in it, this applies to the even fewer number of cases that actually go all the way to trial and where trial results in a criminal conviction. We're talking 1 to 2% of all cases tops. And relatedly, as discussed before, it in no way affects state law enforcement involvement with their federal counterparts at all. So this really only applies to seizure and forfeiture of property initiated and prosecuted under state law, which my understanding affects high tens of thousands to low hundreds of thousands of forfeited property overall in the state. So this bill is laden with exceptions to understand and to nod to the good work that law enforcement is doing. Again, please can seize property if it has evidentiary value for use in an upcoming criminal prosecution, subject to the thresholds, of course. The court can order forfeiture of property in lieu of conviction if the defendant dies or flees the jurisdiction or is deported. And it allows the court to order the forfeiture of substitute property if the defendant sells it, hides it, or otherwise dissipates it prior to a forfeiture order. I know there's a lot here. I'm one of the attorneys that I think Representative McGuire was talking about earlier, so I'm happy to answer any questions that you may have. And I again encourage you to support this bill. Thank you so much for your time.
Okay. Representative Alexander? I just wanna
Thank you. If you'll indulge me, I have a few questions, if that's okay.
Of course.
So this bill would expand the public defender, the need for a public defender for civil proceedings in civil forfeiture cases.
Correct. And what it would do, again, is that it would require the public defender to represent the defendant in that short hearing as a part of sentencing or another post-trial motion, or at the court's discretion, post-conviction, and extend that right to counsel in that very, what we presume to be, in most cases, a very kind of summary hearing.
Okay, and I guess I have a problem with that if there are defendants not getting counsel in criminal cases and then we're extending it to something else. Like, you know, we had a public defender's office testify the other day, like, you know, they're already like strapped with, and they're overburdened with caseload. So even the expansion to some sort of civil case in a limited situation do you believe that could deny justice to those in criminal cases that aren't getting the attention from the public defender they deserve?
I don't think so. I don't know, obviously, what the public defender's office was specifically referencing here. Of course, in this country, in this state, you have a right to represent yourself pro se. Maybe folks are exercising that, and if folks decide to do that, that's absolutely fine, right? But what we are envisioning here with this is that it would add very little workload to the public defender's office to work on this proceeding after a criminal a judgment of guilty or is found by the court, and it can be done at sentencing. So the public defender is already going to show up, right? If there's a motion or the pleading is filed by the state to initiate the forfeiture of the property at that point, or in some other post-trial motion, we don't think it would add a whole lot of work. But it is our point here that these people property owners are being deprived of their right to counsel today. And what Representative McGuire said is absolutely true regarding default judgment. 4 out of 5 property owners nationwide can't even show up to the civil courtroom to contest the seizure and forfeiture of their property, because attorneys are expensive. And if you lose $1,000 car, it doesn't make sense to hire an attorney for $3,000 just to try to get that car back, and maybe not. Then you're out of $4,000. Also, trying to deal with the legal system on your own as maybe somebody who is unsophisticated in the law that's a tall order.
I guess you just, if I could, you just told me that some people represent themselves pro se in criminal proceedings, and then you're telling me that they need a lawyer to get their $1,000 car back. But I would argue that absolutely you should not have to represent yourself pro se in a criminal proceeding. You should have a funded public defender.
We absolutely agree, but it is your constitutional right,
I understand
sir.
that.
Yeah, that was the only point that I was making. If a person makes that choice freely and clearly and intelligently that they want to do that, that is their constitutional right. But we absolutely agree. We want to see people represented in these proceedings.
But I'll wait a little bit.
Representative Smith?
Thank you very much. Thank you. Have you had an opportunity to review the representative's amendment? And do you support the language of the amendment?
Thank you for the question. Yes, I have.
Thank you. And if I could just follow up, I don't want to belabor this point that Representative Alexander's making, but when you say that an individual has the right to proceed pro se, I guess I can't separate that statement from another famous statement that was made in another context, that both the rich and the poor have the right to sleep under bridges, understanding that the rich aren't going to sleep under bridges and the rich aren't going to be underrepresented. Yet the point that you seem to be making is we shouldn't worry about that.
I'm sorry, just to be perfectly clear, and thank you for the question.
Not really.
No, I think my point was just tangential relating to what the public defender's office may or may not have said, relating to why or how people are not getting represented in court today. Again, you have a constitutional right as a criminal defendant to choose whether or not you also have a right to counsel, but you have a right as a defendant to reject that counsel and to proceed to trial pro se. That is your constitutional right. And just to clarify, what we are saying is we would like to see that right to counsel extended to more individuals in the civil asset forfeiture proceeding process, because it is really a part of the criminal trial and conviction in our view. It is kind of through a work of legal fiction that the process is technically against the property itself and not the defendant, when obviously the rights of the defendant are implicated when you take his or her property. So and I hope I clarified. Okay.
Representative McFarland.
Thank you, Mr. Chairman. I believe you were here for Representative McGuire's testimony and his answer to my question. Particularly in light of what you were just describing around the hypothetical poor defendant, and I second Representative Smith's comments in that regard. What is your point of view on whether it would be meritorious to increase the $1,000 and $5,000 amounts that are written in the bill?
Thank you for the question. I think Representative McGuire arrived at those numbers as not only a point of compromise, but also looking at some of the data that my law firm has compiled around the country that points to that the median value of seizures in most cases, it's not $10,000, $20,000, $30,000. It's actually quite low. And it varies from place to place. But really, typically what we see is a median value between $800 worth of property and about $1,500, $1,600 at the high end. So this number, I think, was, for policy reasons, designed to protect the most vulnerable people and the people who likely are not going to be involved in these, they're not drug kingpins if you're driving around a 1996 Saturn Ion and have $300 of cash in your passenger seat.
Any other questions? Representative Alexander.
Thank you. Thank you for taking my question again. So you've read the amendment Representative Smith asked, and you're in support of it. My question goes back to my previous question about burden of proof. From your testimony, you indicated that the burden of proof, in order to say that you do not have actual knowledge of the crime, would be on the innocent person to prove, right?
Thank you for the question. No, it would be on the state in that context, in the context of the innocent owner hearing. So basically how this works, if you allow me to explain, the innocent owner comes to court and says, hey, grandma comes to court, say, hey, that's my car. I had no idea my grandson was using it to sell drugs. If the court accepts that and the state does not wish to proceed with the forfeiture, grandma gets her car back, right? She can show the title. She can say, I was out of town. I had no idea, right? If the state says, wait a second, we think maybe grandma knew, then it would be their burden on a preponderance of the evidence standard to show that she had actual knowledge that the vehicle was in fact, or that she knew that the vehicle was in fact being used to transport drugs. So that is on the state to prove.
Thank you.
Would grandma have a right to court-appointed counsel?
Under this bill, no. I mean, we would love to see that, but that was one of the compromises that we had to work out. So,
Any other questions? Representative Morton?
So to follow up with what, thank you, by the way, and thank you for the question here. Follow up with what Representative Alexander was talking about. The last sentence in this paragraph, the state summarily shall return property such person. Years ago, I worked at a car dealership and somebody came in to take a test drive. And then a few hours later, we were like, where'd that guy go? He didn't come back yet. And a couple days later, the Tilton police called us and said, we got your car. And they could tell by the dealer plate and some other information. And so it was used in a drug crime. And I don't know what extent there was or whatever, but it was about 2 weeks before we received the car back at the dealership. Obviously, it was quite obvious that we had no knowledge of what the car was being used for. So when it says state summarily shall return property, I mean, that doesn't really say, like, is there a time limit? I mean, can they just do it a couple weeks later? I mean, in that case, it was literally like 2 weeks went by before we could get the car back.
Thank you for the question. I'm sorry, would you mind directing me to the page and line that you're referring?
It's on the amendment on the third paragraph at the last. It says state summarily. In this case, it was a town, but I guess that would fall under the same circumstances being the state.
Yeah, so as we understand it, because of the way that property might be stored following a seizure, we want to give law enforcement some flexibility to make sure that they can find the right property, that they can retrieve it, and that they can make sure that it has no evidentiary value for potential use at trial. So it's designed without I believe without an explicit timeline to afford some flexibility. And this was, again, a part of the compromise process. We would like to see, of course, property returned to the innocent owner, to you, to a secured interest owner, as soon as possible, as soon as practical, right? But we understand that in some cases that may not be possible, and we're just trying to give folks flexibility to get that property back. Thank you for the question.
Any other questions? Seeing none, thank you. Is it Derek Catalano?
Good morning, Chairman, members of the committee. My name is Lieutenant Derek Cataldo from the Manchester, New Hampshire Police Department. I currently work in our Special Enforcement Division, which handles primarily all our drug investigations, gang investigations, firearms investigations, and I personally deal with not pretty much all of our department's drug asset forfeiture. My written statement is going around. I'm not going to read it verbatim to you. I'm just going to hit some key points. One of which I'd like to start with is, and lastly, I'm here on behalf of the New Hampshire Police Chiefs Association. Our position in law enforcement is that our current bill is well vetted, fair, reasonable, has multiple layers of oversight, from the officer's initial decision to someone like myself, a supervisory review, to the Attorney General's office decision to move forward with the case, and finally to the judicial process where it plays out. We think it's fair. We think it's reasonable. We think it's a process that works well. One thing that I would like to point out is the changes to the current asset forfeiture were characterized as minimal. Law enforcement is in complete disagreement with that. We feel the changes are quite drastic, and I'll go over our position about why that is. Primarily, one of the issues is and it was mentioned, I think, by Representative McGuire, the change for the presumption of forfeiture for currency that is found in proximity to drugs during investigation. So the reason that that currently exists is it is extremely difficult to connect a direct link between cash found and drug sales. Obviously, drug dealers don't provide receipts. They're very careful with their ledgers and if they even keep them, or conversations or communication between themselves and their customers. And a large portion of our seizures occur from street level interdiction stops, which is often a patrol officer observing drug behavior, making a stop, having a roadside investigation, seizing a car on a search warrant, discovering large amounts of cash, large amounts of drugs, and then conducting the civil asset forfeiture process. With this change, that will be completely wiped away because it's almost impossible for us to prove that specific cash came from drug sales. The process now is there is a presumption of forfeiture, which means we bring that cash in and the person can come in and show that I got that from inheritance. I got that from, these are my checks that I cashed. There's some documentation. I sold a car. Here's the bill of sale. They can show that that cash is from legitimate means and the cash can be returned to them. It is written that way because of the difficulty of proving such a thing. Even in some of our long-term cases where we do more in-depth investigations with undercover officers, with extensive surveillance, even then it will be difficult to prove cash we find in a specific place is the actual cash directly linked to the drug crime and the drug sales. That is a major, major change. And building on that, taking into account our neighbors to the south of Massachusetts, their asset forfeiture law, I think should be a major consideration here. So the state of Massachusetts currently has an asset forfeiture law that is fairly similar to ours, where once an officer seizes some money found in proximity to drugs, the person who it is seized from can come forward and provide evidence that that is legitimate money that they got from legitimate means. If this bill passes, we will now have that flipped and Massachusetts will remain the way they are. And the reason I point that out is many drug trafficking organizations that are operating in our state are based in Massachusetts. So right now there is essentially a even fiscal risk for them operating in either one. So some will come up here, they'll send, we call them runners, people who drive up, they sell drugs, they return to Massachusetts, and that's where their base of operations is. Now, I obviously cannot tell you that we'll have a massive influx of drug trafficking organizations changing home bases here, but it is a factor that I think needs to be seriously considered with a bill like this, because there will certainly be a less fiscally risky environment created here. And like any business, that is, they will look for a environment that is easier for them to operate in. And I think that's just a reality of this bill. And I think that's something law enforcement and myself and the association has a responsibility to point out to you, that that is something we think you should seriously consider. A couple other things I wanted to mention is I heard some talk about seizing grandma's car, and I think that is currently certainly not a practice that we do. And if you go to on page 4, line 10 of the current bill, it's lined out. But, and I think the gentleman before me pointed out, the state will need to prove that grandma in this case was a consenting party to the felonious violation and had knowledge of it. So we're not taking people's property that is completely innocent and not a party to any of these crimes. That just, that is not correct. That doesn't happen, and it's not something that we do. The other talk about the amounts, so that is accurate. I do not submit anything below $1,000. But I heard some talk that a drug kingpin won't be driving around in a sort of beat up car with a couple $1,000 or below that. No, they won't, but the people that I referenced earlier, they're runners, the people that they employ to sell their drugs as part of the organization will. They will drive around. And we just had a seizure recently of almost 1/4 kilo of product with less than $1,000. Because what they do is they send them out, they do their sales for the day, they come back, they drop it at either a stash house or a stash location, they pick up more product, they continue their sales. So the fact that $1,000 or so is the limit doesn't necessarily mean we're targeting or going after very low value users. That is not the practice that we use, and that's kind of, I think, where that $1,000 limit comes from. Certainly I could understand Representative Bergeron that it seems quite low, but that's sort of where we get the idea of it can be fair to seize amounts around $1,000. That's where that comes from. So in closing, I hope we find that the committee would find this bill inexpedient to legislate for those reasons. A lot of the talk about the legislative portion is a little bit out of my purview, so I can't really speak to that. I will certainly leave that to you and folks who are more well versed in that, but I'll be happy to take any questions.
Representative McFarland?
Thank you, Mr. Chairman. So just to follow up on what you were saying at the end there, and if we assume for the sake of discussion that the limits specified in the bill are appropriate, and it sounds like they're in line, as Representative McGuire was asserting, with your current practice, can you explain to me where you, I think, just laid out for us that it is commonplace for these criminals, presumably being well aware of some of the limits in question, to make a point of only carrying less than $1,000? That is their common practice, and yet you're saying you only address the over $1,000 circumstance in your current forfeitures. How do those two comport? I mean, wherever we set that number, it sounds to me like what you're telling us is that the actors who are not who don't really have criminal intent may be carrying any amount of funds, whereas the real criminals are going to stay below that threshold no matter what.
So I wouldn't say that it's a practice for them to carry under that. I was just using that example as that person. So the person that we seized just under 1,000 still had a large amount of product on them. So they would have sold well over 1,000, probably into the 2,000 to 3,000 range. I was just saying in that general range, that's why it's around there. Because even though it is a fair assumption for someone who's not familiar with kind of these organizations, how they practice, why would, a large dealer or a large organization carry so little? I think it's for the exact reason, one, they don't want to get robbed and lose a lot of money. They don't want to have law enforcement stop them and lose a lot of money. So setting it where it is, I think, is a reasonable amount where we're kind of putting out the users who might have a couple $100 on them, maybe, looking to buy a few grams, but keeping it a threshold where it's those traffickers who use runners, we can still effectively seize currency from them.
Thank you.
Representative Rombo? Representative Rombo? Yeah. Nope, sorry.
Thank you. And thank you for taking my question. To your comments about Massachusetts and the concerns about the impact from drugs in Massachusetts and New Hampshire, are you aware of, or can you share any information on other states maybe who have had differences in their forfeiture systems or made changes in those legislations, how that may have impacted moving the drug trafficking focus to a neighboring state?
I can't. I don't. I just am basically going off of our current situation and a lot of assumptions based on human behavior. I don't have any specific.
It wasn't intended as a trick question. I'm just curious to see if other states had dealt with that sort of shift.
Right. No, I think it's a very fair question, and
thanks.
Yeah, I would be curious myself to look into that now. Thank you.
Thank you.
Any other questions? Seeing none, thank you. Tim McCasm? Okay. McCasm? Last one. I think so, yeah. Yeah. That's it. Okay. Oh, one more time. There you go.
Thank you, committee members, for hearing my testimony. My name's Timothy McIsaac. I am a lieutenant with the Nashua Police Department. I've been there for about 21 years now. Just as far as a little background, I apologize I didn't have a handout for everyone. I can certainly email that and have it forwarded to you for your review. I won't belabor the point. I'm to touch on a lot of the same points and mostly the more factual points that I was concerned with in opposition to this bill that Lieutenant Cataldo eloquently spoke on. Was the removal of certain verbiage in the current statute or current law that allows for us to seize funds that are within proximity to controlled substances. While that being a minor alteration of the verbiage that exists in the current law and changing it to what it is now, I can't understate the point of like what Lieutenant Cataldo previously testified to, is that often drug dealers, have cash on hand and have those funds coalesced in their business. It is a cash business and it's quite profitable. I think if by changing that verbiage, it would allow for officers to impair their investigations, to seize funds when they believe it is involved in an investigation. When they're in the course of an interdiction stop or a long-term investigation, if we come across large amounts of cash, it is typical that we would seize it and continue our investigation. Like Lieutenant Cataldo stated, we're not within the, we continue our investigation even once it's seized. And we obviously, when a defendant or someone, an involved party that could be caught up in an investigation, can offer proof that the funds that we seize or the assets we take are believed to be not ill-gotten and not illicit, we certainly can take that as part of the investigation and return items when they are necessary. We proceed into proceedings when we don't feel like that is legitimate and that they are ill-gotten gains and illicit means. The reason why, obviously, asset forfeiture has been established is to take away that funding mechanism for drug dealers and make it a less fruitful endeavor. Additionally, it helps dismantle these organizations that have webs of people working for them and makes it so that they can't reestablish easily. By working it through the current system we have, I believe there's checks and balances. Within our agency, we often, when we take assets, we do so with a concerted effort to have all the facts at hand and do so, and it lets it play out through the court process and have due process afforded to the person who we take the assets from. I'm not aware of any situation that was kind of slightly characterized by some of the previous testimony that we're taking grandma's car and trying to take that without a common sense approach to the matter. I can't think of a situation on hand that in my time at the police department that we've someone who's been victimized by our practice of seizure of assets. Certainly there may be people who disagree with that, but I certainly can speak to my own knowledge of the situation. Without belaboring the point, I do feel that the current, while that line item from line 18 to 21 that's been lined out, which I'm referring to as the proximity removal, that is from my standpoint, is from law enforcement, the most significant change that would affect us on a day-to-day basis and how we attack the drug traffickers that do work within New Hampshire. The rest of the legal proceedings, and as far as the changes, I can't speak to the court's capacity or abilities to handle that and what legally is appropriate, but obviously that's within your guys' purview to make those assumptions and determinations. Thank you.
Any questions? Representative Manos?
Thank you, Mr. Chair, and thank you for taking my question. When assets are ultimately forfeited, do you know where either the cash or the asset goes? Where does that money ultimately end up? Do you know?
Typically, when we take an asset, we obviously go through the procedure with the Attorney General's office. The money is held in our evidence until it's transferred to their custody. If it's a vehicle, say, where we hold it at our facility and we maintain an overwatch of it to ensure that it doesn't diminish it. Like, for instance, a common one would be a vehicle. We maintain overwatch of that by our procedure to ensure that it doesn't diminish in value. It is vehicles aren't taken by us generally as a matter of ease, because typically the vehicle values we're seizing aren't of great value, and they're often kind of labor intensive to maintain and stay with have to keep them current, and there's a labor manpower involvement in that. Keep our mechanics from having to start them, regularly check them, make sure they're still operational, so we're not diminishing that asset, because inevitably we know the court process proceeds, and it's not a guarantee or anything for certain that we will be getting that asset as a seizure.
Follow up?
Thank you, and thank you for taking my follow-up. Do you know whether the money ultimately goes back? It goes to the Attorney General's office, apparently, but does it ultimately go back to fund police departments? Do you know?
Yes, a portion of the funds, as determined by the Attorney General's office in the current law, will come back to the police department, and it will go into an asset forfeiture fund at the police department.
Representative Horgan?
Thank you very much. We've heard a lot of talk about Massachusetts, and as you know, Nashua and Tingsboro, Massachusetts are divided by pretty much an arbitrary line drawn on the map. So are there suppliers in New Hampshire who are selling into Massachusetts? So is this just in the context of a regional market, or is it actually like the suppliers are one side of the state line and the customers are on the other? So
I will say that it is twofold. We are very close to Massachusetts, and we are very close to Lawrence, Massachusetts, which is a designated source city of narcotics. I would say, if not all, but most of our narcotics do come from Lawrence, Massachusetts by origin. It is a combination of dealers coming into the state to deal, and also local dealers traveling down to Lawrence, Massachusetts, picking up a large quantity and bringing it back. And it's often, an example provided earlier was a drug and addiction stop where a motor vehicle infraction and a subsequent investigation unfolds based upon observations of officers and investigators. And often, sometimes when we come across quantities of cash and drugs coalescing together in a vehicle, it is sometimes through investigations we find that these people are traveling immediately from either Lawrence, Massachusetts, or going down to Lawrence, Massachusetts to purchase narcotics or return to Nashua to sell.
thanks.
Any other questions? Representative Tripp?
Thank you, Mr. Chair. Thank you for taking my question. So if they're going down to Massachusetts to buy their product, I would assume that they have a fairly large amount of money, but they wouldn't have any product at that time. You know, how does that work out in your investigations?
It could be a variety of reasons. Certain dealers operate in different ways. Some dealers they bring down, they buy a certain quantity of a certain drug, but they may have another drug in their possession. Often we're seeing a lot of fentanyl and methamphetamines in Nashua now, and they kind of the dealers typically operate within those two drugs quite a bit. So sometimes their sources are different, different locations. Sometimes they are, in the course of them conducting sales, they are returning to their eventual, say, home base, if you will. So they could go down and pick up a quantity and be traveling throughout different locations in Nashua where we come across them in our investigations, and they have quantity.
I don't have any more pink cards for that bill. Is anyone here that wishes to speak on it? Representative Papavilli Mueller.
Thank you very much, Mr. Chair and members of the committee. As a co-sponsor, I just wanted to take a couple of minutes to quickly go through a couple of the topics that came up during the discussion of this bill. I'm going to try not to repeat anything that was already said because once is enough. We had questions about the impact on public defenders. I hope that by now it's pretty clear how minimal that is. I do not believe that one person who needs a civil defender in a criminal case would be unable to obtain it because of the minimal strain put by including this civil proceeding at the end of a criminal case. It is literally a very, very minimal amount of time and effort that be required, and it should not put a strain on the system. We've spoken about the fact that there are minimum amounts in this bill. They are quite low. Again, in a different state that has fewer protections, we would maybe fight for more. In this case, I think the current levels work fine. I just want to address one significant objection to this bill from our law enforcement testimony, which is the change of presumption for the forfeiture of cash found in drug investigations, where this bill would allow, would require would put the burden on proof on the prosecutors to prove that. Look, I have full confidence in the ability of our law enforcement to prove that, the tens of thousands and hundreds of thousands they are typically confiscating at the end of long investigations into drug organizations are proceeds of criminal activity. The bill still allows for plea bargains that may include keeping the confiscated property and so on. But if this becomes the sticking point for this committee, I would submit to you that even if you decide to take that minor part away of it, even though it's an important part to me and I would encourage you to keep it, the rest of the bill is absolutely worth an OTP because it addresses significant burdens and it will make life easier for the court system, for the prosecutors, and for the victims. And I really appreciate your time. I know it's been a long hearing, so I want to wrap it up.
Any questions? Seeing
Thank
none,
you.
thank you. Are there any other people that want to speak on this bill? Seeing none, I'm going to close the hearing on House Bill 615. And we are at the time to open the hearing on House Bill 509. And I recognize Representative Popovici Mueller Representative Dan McGuire to introduce it.
Thank you very much, Mr. Chairman and members of the committee. For the record, my name is Dan McGuire, and I'm from the town of Epsom, and I'd like to introduce House Bill 509. As we talked about just on the previous bill, the amount of reporting of asset forfeiture is fairly minimal, and this bill adds many specific sort of fields, if you want to think of this as a, getting a spreadsheet or a table or something like that. So this bill would add much more detail about each specific kind of forfeiture, what was the value, what was the offense, what was whether the forfeiture is going to go to federal court or state court, things like that. So the main problem we have had dealing with this kind of legislation is information on exactly what's going on, and because we get sort of summary kinds of things, but we don't get this level of detail. So it would be nice. I don't think. The bill has a fiscal note that says that it's going to be, I don't know, it looks like about a half a person's worth of work, but I can't imagine it's anything like that. If somebody who has access to the court system's computer system, I think could go through the number of cases here, 100 cases or 200 cases or whatever, create this sort of summary information relatively quickly. It's not a half-time job for a person, in my opinion. And I'm happy to answer questions.
Representative Alexander.
Thank you, Mr. Chair. Thank you, Representative. Why is it in the public's interest to know this information?
Well, thank you for the question, but when we make legislation, we have to know what's going on to decide is the public interest being satisfied, right? I mean, if we don't know, suppose we were to find out, for example, that 90% of the cases involve cheap cars and $2,000 worth of cash, we might think we're sort of over enforcing something, or it'd be a different character than if most of the cases are $100,000 and houses and things like that, right? So we want to know what's going on.
Representative McFarland.
Thank you, Mr. Chairman. Representative McGuire, I'm looking at the bill. I'm looking at rows 24 and 25 of the bill. If there is a forfeiture that meets the criteria of that clause L, it talks about made without the federal agency's involvement in the seizure. And that seems to me to be a clause that is subject to an awful lot of interpretation. Could you help me understand, for example, if a stop was made by state or local officials, and in the course of the stop, they had their dispatcher make reference to certain federal databases, would that then involve federal agencies' involvement? And might there be a need to adjust that language?
Well, thank you for the question. I guess that's an interesting interpretation that I hadn't thought of before. But in general, I think what we intended here was there active personnel involved, like the FBI or something like that, rather than database kind of things.
Follow up?
Yeah, no, and I perceive that intent, and I am very sympathetic to that intent. I just want to make sure we structure the language closely enough that the intent is what is reflected in statute.
Thank you.
Representative Rombo?
Thank you. Thank you for taking my question. To the extent this additional information might inform some of the concerns that were tried to be addressed by the prior bill, by HB 615, in your opinion, would there be benefit to this sort of reporting bill, to try out this sort of reporting bill in advance of implementing the changes contemplated by 615?
Yes, thank you for the question. And I guess because I submitted I submitted the other bill, my answer is no. I don't want to wait for that. And to tell you the truth, I mean, I've been working on this area and proposing legislation on it for more than a decade. So, you know, it's I think it's time to make progress. We have made some. I mean, we did get in law the fact that criminal conviction is a prerequisite to forfeiture. The problem is the way we have gotten it doesn't have teeth. It doesn't always happen that way. So I think that's an important goal of the first piece of legislation.
Thank you.
Representative Smith?
Thank you. Representative, I might have misheard you. I thought I heard you refer to the fact that it would not be a particular burden on the court system to get this information, but I thought that this was focused on the Attorney General.
Yes, thank you for the question. It's the Attorney General's office which makes this this report, but I think the data is contained in the database that's of cases that's maintained by the court system. But I think in general attorneys have access to that database. I could be wrong about that, I suppose.
Representative Turer?
Yeah, thank you, and thanks for taking the question. Just maybe a technical clarification on line 2, where it says 120 days after the close of the fiscal year. I'm wondering if it needs to sort of specify what date or what part of this whole proceeding will trigger it to fall within a given year's reporting. Basically, you know, you've got the date of the crime, you've got the date of the arrest, you've got the date of the court hearing, you have potentially date of a seizure, which is at a different time. I wasn't sure if you had an opinion on whether that should be part of this.
Yes, thank you for the question. So you're asking about the date of the. There is some ambiguity in the sense that, you know, it's an ongoing process as to what's happening with a given case, right? So a case may be through seizure and waiting to go to court at the time you're going to report on it, right? And I think that's part of current reporting as well. I mean, it's not a new problem. I mean, this 120 days is existing law. And so I think in general, part of this is you report on the status of this particular case, right? You can think of a table with one line for every case. And so the status of that particular case could be, you know, waiting for court and not yet. You know, so you would fill in on that table the things that are currently known, right? But not things that are obviously not yet known.
Yeah, just one follow-up on that. So that's actually an interesting answer, which I hadn't thought of. So this is not necessarily a single reporting of a forfeiture a forfeiture could, if we don't clarify what triggers the reporting requirement, could fall into multiple years of reporting. And I worry that that might degrade the quality of what we know if things are sort of not unique.
Yes, thank you for the question, but I don't really think so, because you could sort the table and find the things that are final, right? And so, you know, and go from there, right? And use that kind of data.
Any other questions? Representative Manos?
Thank you, Mr. Chair, and thank you for taking my question. I'm wondering if this is data that is already tracked but not reported, or is this data which is not tracked? And if it's not tracked, is it easily available? Thank you.
Thank you for the question. No, I believe this is data that exists, so it is tracked with the cases, and so therefore it shouldn't be. I don't think there's anything here that should be very difficult to report on. Now, the one place where I might have some. I would sort of temper that answer is number 20. So I don't know for sure that when a case goes federal, right? When a law enforcement decides to take a case to the federal prosecutor and the federal prosecutor accepts that case, whether our New Hampshire database has that case in it. You see what I mean? So that's an area that might sort of require extra reporting from the law enforcement to the Attorney General to add to this report.
Follow up? All set? Okay. Any other questions for Representative McGuire? Seeing none, thank you.
Thank you, Mr. Chairman.
Representative Wheeler, come on up.
Thank you, Mr. Chairman. I was excited to congratulate my old seatmate, Representative Mannion, on his temporary appointment as chair.
I also got temporarily appointed as vice chair. So.
Well, I'm not congratulating you, Representative Alexander, but it's always a pleasure to be here today before House Judiciary. Ranking Member Smith, thank you for having me. I last term served on the House Criminal Justice and Public Safety Committee, and Representative McGuire had brought forward legislation around civil forfeiture. What we had determined and what we had found in the conversations around that legislation is there is a significant lack of data when it comes to these procedures, these, whatever you want to call them, the civil forfeitures. And this legislation, I think, is an appropriate change to statute, which would allow us to report this data in a more comprehensive way. I think Representative McGuire handled it well. I think Representative Popovici-Mueller will handle it even better than I could. So I'll just leave it there. I was a former member of the committee that handled legislation that he had proposed last year. And as somebody that wants to make informed decisions as a legislator, I would think a more comprehensive view of what the civil forfeiture procedures are about is appropriate for the legislature to do. So thank you, Mr. Chair, for the time, and I'd be happy to take any questions, but others could answer them better than I.
Great. Questions for Representative Wheeler? Seeing none, thank you. I think I had a pink card.
Yes.
Alistair Whitney.
It's me again, Alistair Whitney for the record, Legislative Counsel at the Institute for Justice. I'll keep it brief. We support this bill and we encourage this committee to pass it. We have looked at the data collected for forfeiture practices in all 50 states. New Hampshire, we simply don't have much data at all. So we think more transparency is better. That would give this body, the general court, the information and the tools necessary to make more robust forfeiture process related reforms. And we think more transparency, more information is always better. With that, I'm happy to answer any questions that you may have. Thank you so much.
Any questions? Representative McFarland?
My only question is with regard to that clause L again. If we were to contemplate an amendment to narrow the language to the sponsor's intent that we heard from his testimony earlier, do you believe there is any circumstance that would exceed contemporaneous human involvement by the federal agency that you'd want to include in there?
I'm sorry, I don't quite understand the question.
So I'm looking at clause L, and as we were discussing with the questions to Representative Maguire, it seems that that could be interpreted broadly, and it seems that his intent is to interpret it more narrowly, only to apply where the federal government agency is really directly and contemporaneously involved in the arrest. I guess I'll simplify my question. Is there a different set of language that you might suggest for that would be better in your mind?
Thank you for the question. I'd be happy to propose that language if that is the intent of Representative McGuire and the sponsors. I think the way that it is written right now, my interpretation is that it is limited because it limits it to federal agency involvement, and I think that would, because it talks about the seizure and not the forfeiture, that it is limited to instances where state and local authorities might be working with their federal counterparts in drug interdiction task forces, for example.
Thank you.
Any other questions? Seeing none, thank you. And is it Daniel? Oh, I didn't even know who it was. I couldn't even see that. Difficult to read. Apologize, Representative.
Thank you, Mr. Chair and members of the committee. I'm the one who should apologize for my terrible handwriting. And it's only my second card filled for the day, so I cannot exactly plead exhaustion here. I just want to briefly, as the prime sponsor on the bill, explain why it was brought up, right? If you remember, we had discussions in previous years about, whether changes to the civil forfeiture laws need to be made in any way. And one of the major concerns, again, was the lack of data. Now, we do have the existing, 617 column 12 Roman numeral 1 language. So we already have a report, but we had a statutory committee created last fall that looked at the forfeiture, civil forfeiture, and we examined that report in detail, and it really wasn't useful at all for policy or for transparency because it has very, very limited data that doesn't really tell you what happened. So this is just an attempt to make the data available both to the public because, they should know what we are doing, and also to the, people who make policy on just more information about exactly what's going on that would help us in drive the right policy. The burden is on the Attorney General, as it was. We do not change the deadlines. So any concerns about the incomplete cases, really, they are already applying to current law. The current report has the same exact concerns. We are not touching those deadlines in any way. We feel that all this data that we are asking for is already available. I mean, if you look at it, there is nothing here that wouldn't be in a case file. Even the concern raised over line 20 on whether the forfeiture is sought under federal law, local prosecutors and federal prosecutors have to be aware of when the case is becoming federal because they're talking about the same property. They got to coordinate. So the local prosecutors would know that the federal agency is coming in and saying, no, that's my case now. You guys stand down. We got it. So that data would be available and would be easily reported to the Attorney General. And we tried to make this as simple as possible. We actually looked at different states and we pared down some of the other requirements that were in other states because we felt they were too much for New Hampshire and for the questions we were trying to ask. And the last thing I'll say is that how many bills do you have that really have, nobody testifying against them, nobody signing up in the blue sheet against them? I'm not going to hazard a guess on any online comments, but I think this is a very basic, common sense, minimal expansion of reporting that would bring great value to everyone.
Any questions? Representative Turr?
Thanks for taking the question.
Of course.
I'm going to circle back to the same question I asked earlier about sort of establishing a trigger date for when something gets reported versus what Representative McGuire said, which is essentially any case that could potentially be in this process would get reported at any point at which it's in the process. I guess I'm wondering, what would your thoughts be on amending this to basically trigger this at the final state when we know sort of what the state's actual seizure was? And the reason I asked it, not to run out the question, is particularly we have these clauses about innocent owners and things like that. You know, I could see that person being reported as the owner at one point before they've claimed their innocence, and you know, it seems like it could get very confusing in terms of what the value of this data would be if you're not looking at a finalized, settled process at the end. So would you be supportive, or do you have a reason why that would not be a good change?
Thank you for the question. I really appreciate it, and I appreciate your concern on this. Obviously, I recognize that if the committee would like to amend the legislation, the committee may amend the legislation in any way they see fit, and that's the prerogative of the committee. Personally, I would support the language as written, and here are the reasons why. First, all this data that is reported is already public data from court systems. So if there is any concern about somebody being, temporarily, named as somebody who's being prosecuted, again, that's public information already. Also, you will notice that we don't really have names here. We have a criminal case number, so people could go to the courts and find out that information. But this doesn't say, Joe Johnson is being prosecuted. It just says case number, yada, yada, in this court. The other concern that I would have over only reporting finalized stuff is that some of these cases can take a long time to run their way through courts. So it would really prevent us from seeing how much property was seized in the previous year. We may see it 2 and 3 years down the road, therefore, making it harder to judge. And the volume of this, the previous year report has maybe 20 lines. It's not one of those spreadsheets with thousands and thousands of cases. It's, a limited number of them. So it should not be difficult at all to, again, just filter by, hey, I want just to see the finalized cases, or I would like to see everything that was seized, regardless of what the current disposal was. Again, if I want to look at, say that we are already in May and the 120 day has passed, it's May 2025. If we would change the language, then by looking at the May 2025 report, I would not be able to see how much stuff was seized in 2024, because a good part of that would still be litigated. So that's really the reason why it is written this way in the current law and in our law. And, again, up to the committee. Thank you.
Thank you. Anyone else have any questions? Seeing none, thank you.
Thank you so much.
Is there anyone else that wants to speak on House Bill? On the right one, yeah, 509. Seeing none, I'm going to close the hearing on House Bill 509.
I think there's a public interest in knowing who won the lottery. And first of all, playing the lottery is voluntary. So if you don't want to run the risk of winning and having your name exposed, you're free to not play. But also, you can turn a winning ticket over to a trust or other way, or to conceal your identity, as some people do. So
All right, we have a few minutes, so we're going to open up an executive session on House Bill 485 that we heard last week, and I recognize Representative Alexander for a motion.
Thank you, Mr. Chair. I move on to pass.
Second.
Seconded by Representative Smith. Any discussion on the bill at all?
I just briefly, I think it's okay to remain anonymous if you win the lottery. I actually think that there's really no public interest in figuring out who won the lottery, and I actually think there's a lot of drama involved when you win the lottery. So, if I ever happen to win, you won't see me ever again, and I will be off on an island somewhere else, and nobody will know because I will be anonymous. Hopefully, thank you.
But there will be signs. Representative Smith, you want to speak on your second?
Thank you. Aside from my strong belief in personal privacy, if you look at the language in this particular bill, it is very specific, and there are very clear reasons why privacy might be essential to protect the well-being of the potential winner.
Thank you. Any other discussion on this bill? Representative Horrigan?
Well, just to say, reiterate what I said before in the context of the actual executive session. If you don't want to run the risk of winning and having your name published, you're free not to buy a ticket in the first place. And which is actually, except occasionally when the Powerball gets very high, is actually the economically optimal strategy. And also, you can turn the ticket over to a trust before you accept the ticket too, which is which if it's a large prize is probably not a bad idea anyways. I think the existing law is sufficient. So and I will admit I didn't attend the hearing on this bill, but it's a perennial bill. I've seen many bills in the past. This is a bill that comes up almost every session. So I've always been opposed to it. So I'm going to continue being opposed to it. So
okay.
Very briefly,
Representative
the most compelling reason that I heard articulated in the hearing on the bill for disclosing this is to be used as marketing material for the lottery itself, which I think is an easy interest to overcome in the names of the anonymity that this bill is providing.
Thank you. Any more discussion on it? Seeing none, I'll ask the clerk to call the roll if she's ready.
Representative Alexander?
Yes.
Representative Tripp?
Yes.
Clerk votes yes. Representative McFarland?
Yes.
Representative Morton?
Yes.
Representative Smith? Representative Horrigan?
No.
Representative Manos?
Yes.
Representative Tur?
Yes.
Representative Rombo?
Yes.
And Chairman Mannion?
Yes.
Did I miss? No, I got Tripp. Yep, there's 11 of us. Okay. Yep. 10 yeas, 1 nay.
No, you got to vote. Right. Any objections going on the consent calendar?
I guess. No, I guess I may as well let it go on the consent calendar. But
Okay. And do you want to write a minority report on it?
I
Can't?
actually guess I would like to write one, in which case it has to go on the regular calendar. So yes, so just a very brief one. Yeah.
Mr. Chair, I just want to make sure that Representative Horrigan has, in fact, I know he was not able to be here for the hearing, but to make sure that he has, in fact, read the details of this particular bill as compared with the many previous bills that he has seen in earlier years before he commits to. Have you looked at the bill?
Yes, I have, but I guess I will withdraw my objection to putting on the consent calendar. So we'll see what happens when it goes through the legislative process to see. Yeah, so I mean, I have read the
So
bill.
no objection to it going on consent.
No, you can put it on consent.
Thank you. All right, I'm going to close the executive session on House Bill 485. House Bill 601, if we just want to take a straw vote to see who is interested in
Yeah. Oh, yeah.
ITL for that. If anyone's in, if you could take a look at that one, 601. That's relative to causes of action against companies that misstate the impacts of their business on the environment.
Or make a suggestion. And I don't know what everybody's lunch plans are. Would it be possible for us to just come back from lunch a little earlier if we're going to do some of the Suka caucus beforehand? Does that others' schedules permit that, or?
I have a 12:30.
Okay. So, pipe dreams. Okay.
And also, like we have a 3 o'clock deadline, so obviously the chair appropriately wants to at least have some things there, so we meet the deadline for the House session on the 20th, 8 days from now. So that's like, so we're in a bit of a time, we're in a bit of a time crunch if we want to have some more bills reporting.
Undisclosed location.
So I guess we can recess until 1 o'clock. Enjoy lunch. I can get my clerk here at least and some other people. .103. So I'm gonna reconvene the Judiciary Committee and open up the hearing on House Bill 587. And I recognize the prime sponsor, Representative Matt. If you could help me out there.
Good afternoon, Chairman Mannion and members of the committee. I'm Representative Matt Saborn de Chouanier from Rockingham 30 Seabrook.
I knew it.
Introducing HB 587 today, allowing admission of one party audio and video recordings in certain circumstances. Those circumstances being domestic violence. So currently, as the law stands, if someone's in a domestic violence situation, if they were to record their abuser, it's actually classified as a felony under the law. This would create an exception for that to allow if someone is recording or is experiencing domestic abuse that they can basically submit that recording as part of evidence collection to a court or a police report. And that's actually I think the language is pretty simple. I didn't have too much testimony today. Does anyone have any questions?
That's it. Any questions?
I know there's a lot of folks here that also here to testify in support.
Yep. Representative McFarland?
Thank you, Mr. Chairman. Representative Sabrin de Chouanier, you indicate the intent is to be limited to crimes of domestic violence.
Yes.
I don't see that reflected in the language on line 7.
Okay. Thank you for pointing that
Well,
out.
I guess let me phrase it as a question because I was intending it as a question. Do you agree with my assertion, and do you think that the language needs to be modified?
If it's the committee's bill now, and if the committee believes that that's the best way to carry out that intent, it could also be used. I mean, what if there's like child abuse happening too? So I mean,
Follow up.
Yeah.
Follow up.
So, I mean, without regard to whether it's domestic violence or not, if we just read the language as written, is or contains evidence of what the person reasonably believes to be a crime. Could you explain to us, in this hypothetical where somebody has taken one of these recordings and is going to be submitting it, how are they supposed to have known a priori that the recording that they are taking against the current law is in fact subject to this exemption? Because how would they have known prior to the start of the recording that something would happen during the course of the recording that would be, in their estimation, a crime?
It's more emergency situations. No, it says reasonably believes.
Okay, so your expectation here is that this is the sort of thing that would happen once they believe a crime is already being committed, and then they can start recording.
Yes.
Thank you.
Thank you for your question.
Any other questions, Representative Tur?
Yeah, thanks, and thanks for the question. The intent of the bill seems pretty clear. I think it's also on the question of the way it's worded. The way I read this, it sounds like you have to provide your recording to law enforcement and utilize for the purpose of court proceedings. I'm feeling like maybe it should also state that you can't utilize that recording for any other purpose, because I could see people potentially posting that to social media as well at the same time, and that changes the dynamic pretty.
Correct. Thank you for your contribution.
Any other questions? Seeing none, thank you.
Thank you, sir.
Representative Jody Newell? Did I get that right?
Yes.
I'm vaguely familiar.
Because we have a long and storied history. Thank you, Chairman Mannion. For the record, I'm actually passing along testimony that was submitted by the Honorable Representative Amanda Elizabeth Soto, formerly Amanda Elizabeth Toll, who is a representative in this body, did not run for re-election this year. This is something that is very important to her based on her personal experience, and so I wanted to share her testimony with you today. Thank you, Chairman Mannion. For the record, my name is Jody Newell, and I represent the good folks of Cheshire 4 and Keene. I'd like to express my gratitude to the committee members for giving me your time and attention today. I wanted to share a little bit about why I'm enthusiastically supporting this change to our wiretapping statute. Last year, as the Honorable Chairman Mannion will likely remember from the Criminal Justice Committee days, his criminal justice days, we heard a similar bill, or albeit one that was too broad in scope and ultimately just unpassable. At that time, the importance of working on and crafting a bill that would address the needs of folks experiencing domestic violence was brought up in that hearing. Fortunately, the Governor's Commission on Domestic and Sexual Violence had been working on appropriate language to accomplish this goal, and this language here is the result of their hard work and diligence. Since then, I've heard from many advocates, domestic violence counselors, and survivors about how having this kind of opportunity to obtain credible evidence of the abuse against them is crucial to holding abusers accountable. The bottom line, as far as I can see it, is that domestic violence is a crime that the vast majority of time happens behind closed doors. It is often well hidden, and victims are kept silent in large part because they fear they will not be believed. No abuser is going to give permission to be recorded in the act of their crime. And this law, as it currently exists, creates one more weapon in their arsenal, effectively shielding them from being held accountable for their crimes or the victim from escaping these circumstances. For these reasons, I ask that you vote OTP on this important, well thought out, and desperately needed exemption to our wiretapping statute.
Thank you. Any questions for this witness? Seeing none, thank you. Pamela Keelig?
Good afternoon, Mr. Chair, members of the committee. My name is Pamela Keilig, and I'm the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. As you might know, the coalition is the umbrella organization for our 12 community-based crisis centers, which provide free and confidential services to nearly 15,000 survivors of sexual and domestic violence annually. I'm here to speak in support of HB 587, which would create an exemption in New Hampshire's wiretapping statute. In New Hampshire, it is unlawful to record or disclose the contents of any electronic or in-person communication without the consent of all parties. As a state, we highly value an individual's right to privacy. However, we have heard countless examples where domestic violence victims and victims of other crimes have filmed their abusers or other folks who are causing them harm, committing these egregious acts of violence against them, and they have had no evidence of abuse. Or they do film them and then they learn that the recording violated the law. So consequently, victims end up facing penalties in the process of seeking relief. New Hampshire is one of only a few states that require all parties to consent to the recording of a conversation. Most all-party states have at least some exemptions for when someone can legally make a recording. For example, in instances of domestic violence and crimes involving sexual assault or abuse of minors, in the case of emergencies or other crimes. If someone is being kidnapped, abused, or assaulted, they should not have to worry about whether the recording they are making in a split-second decision is breaking the law. As part of the Governor's Commission on Domestic Violence, Sexual Assault, and Stalking, the coalition has worked alongside experts across the state to improve our community's ability to respond to domestic and sexual violence and strengthen support for victims in the Granite State. When Governor Sununu reestablished the commission in 2022, he directed its members to monitor and review proposed legislation. One of the legislative topics that was first brought to our attention was our state's wiretapping law and the impact that the current statute has in domestic violence cases. As a small group of us worked over the course of several months, reaching out to different stakeholders across the state and vetting possible legislative proposals, the language before you today is what we ended up landing on as a group. And that includes victim advocates, civil legal representatives, defense attorneys, members of law enforcement, and prosecutors. And so I think the biggest thing here is that crime victims can bring forward evidence of the abuse and not be penalized for it. There are a few other folks here that can speak to the statutory framework of our state's wiretapping law, but I think what we really want to see is that it's especially important in cases involving crimes like domestic violence, where it can be difficult to sufficiently demonstrate the extent of abuse in legal proceedings, that they now have this exemption in law and then aren't penalized for making a recording while they were experiencing abuse. Thank you so much, and I hope the committee considers voting OTP on this bill, and I'm happy to answer any questions.
So we had a bill in criminal justice last year. Did your group oppose that?
We didn't weigh in on the content of that bill because it was a different scope. We had explored whether that could have been an opportunity to look at this issue, but I think the committee had determined that it wasn't germane enough to the underlying intent of the bill, and that we could maybe bring it forward in another legislative term. That's what I recall.
Yes, thank you.
Yeah.
Representative McFarland?
Thank you, Mr. Chairman. To the extent that the committee is contemplating amending this bill as written, could you give us some indications as to what your thoughts are on why it might be either a good or a bad thing to move towards being a full one-party consent state?
I think given New Hampshire's strong support for individual privacy and personal privacy, we didn't explore broadening the statute that far. So I'd be happy to connect with my colleagues and circle back with you on that. But we specifically recognize that without an exemption in our current statute, it's been really challenging for victims in the state who are currently facing prosecution for trying to present evidence of abuse. So we just really wanted to have that very narrow focus to start, if that helps.
Thank you.
Thanks.
Any other questions? Seeing none? Thank you.
Thank you.
Okay, all right. Representative Reed?
Thank you, Mr. Chair, and thank you, honorable members. I was of two minds on whether or not to testify, but I heard a couple of things that I wanted to make sure to clarify, so I decided to testify. But since I'm up here to clarify those points, I thought it prudent to share my experience and why this would be something I'm personally interested in and might have been impacted in an earlier life. When I was 18 in Tennessee, I got involved, my first major relationship, got involved with who turned out to be a very, very violent man. I've lost count of the number of times he was arrested for beating me. He hit me with a car on one occasion. He held me captive in his apartment for 3 days. On another occasion, when the police finally found me, they found me naked with half of my face completely black, and they told me that if I stayed, that this was the worst case of domestic violence that they'd ever seen where someone was still alive. And if I stayed, the next time they saw me, it would be a corpse. When I went to one of these court cases, I got pulled in because I defended myself. It was the time he hit me with the car. And he had some scratch marks on his neck. And so I got arrested and he got arrested. And it became very much a he said, she said situation. Now, Tennessee is a one-party consent state. So if this had happened back in the days where everybody had a handy dandy recording device, I could have armed myself with video recording or audio recording of those 3 days, or him hitting me with a car, or all, multitude of things that had happened. Those weren't the days that I was existing in at the time, but that is why Tennessee is a one recording state. I'm fortunate that the judge believed me because she saw the long history of arrests that he had for this case. It turns out that he had multiple warrants in other states, and he ended up actually killing himself after stalking me for 16 years, killing himself the year I got elected to office the first time. So that's the end of that story. But the judge believed me, but I can only imagine victims, because I've also been in situations where victims were not believed. I can only imagine victims not being believed and having their hands tied. Now, the questions I wanted to directly address that came up, the idea is, how would a person know, and I think this was basically partially addressed, how would a person know that a priori whether or not it would be legal for them to recording? So the point is that they reasonably believed. So even if they didn't catch the crime, it's not illegal as long as they reasonably believed that it was going to be a crime. The other piece of this is that make sure to say that it isn't going to be used for any other purposes. I think that can be clearer, but it is already in the bill, which is that it's legal so long as it's provided to law enforcement. So it's not legal in any other context or for the purposes of a court proceeding. The only thing I would clarify, I think, is what crimes exactly do you want to capture in this? Because I don't necessarily know that you want to capture every single crime in this. If the argument is this is an urgent situation where a victim doesn't have a chance to question whether or not it's going to be legal and has to whip out their phone and, oh my God, this person is being violent. Maybe you just want to capture violent crimes. Maybe you just want to do domestic and sexual violence. Maybe it's really up to the committee, but I would just ask that you question, is it every single crime that you want to capture in this? Because I could foresee people doing kind of an entrapment type scenario and I got them saying or doing something. It's just a consideration. I'm not saying I'm opposed necessarily to this language. I just think it's probably a consideration that needs to be discussed. And that's my testimony.
Thank you. Anyone have any questions? Representative Turer?
Yeah, thanks. And by the way, thanks for sharing this in this setting. I just wanted to follow up on that one point that I raised earlier, which is I see what you're saying. I feel like in the way it's worded, it sort of sounds like if you turn it over to law enforcement, then the recording itself was legal. And that's, I guess, my concern is that, it doesn't say that there's any other prohibition on what you use. It's just you were able to record it because it was turned over to law enforcement. And that was why I was thinking a modification might be needed. And I am open to hearing. I don't want to restrict someone's ability to share that with their legal counsel share that with their family. So I'm not sure how to draw, if we were to modify this, how to draw that line exactly. But I guess my concern would be not to allow it to be used in sort of any public setting. I don't know what your thoughts are.
I agree. I think that if it passed as is, which you have plenty of opportunity to amend here on the floor in the Senate, I think most judges would read it as it's intended, as we all know it's intended to be, that use, that specific use is the only legal use. It says utilized later in the sentence, but that's specifically to court proceedings. So, which presumptively that's what law enforcement would be doing with it as well. However, if we're going to amend it, I think it's definitely worth making sure that that language is as tight and clean as possible. So if you're going to, for example, talk about, well, do we want to capture every single crime in this? Then definitely go ahead and fix that language. But I do agree with the intent that no other use other than use to prosecute someone who's committed a violent crime should be kind of blessed in this.
Yeah, I'm thinking if we just put solely for the purpose of court proceedings, that some might be simple enough to clean it up, but we can entertain that. Any other questions for this witness? Representative Manos?
Thank you, Mr. Chair. Thank you, Representative Reed, and thank you for sharing your story. I wanted to ask you about domestic violence that doesn't rise to the level of a crime. I mean, there are certainly many, many instances of domestic violence that are not actually crimes. And so I wanted to ask you about whether this should be broader than just in the situation of a reasonable belief of a crime. Thank you.
Thank you for the question. While I can generate examples of things that I would consider to be domestic abuse, though not necessarily, I guess, violence. Things like for example, and I'm very anecdotally, I had a neighbor, her name was Rose. I would walk my dog. I could only talk to Rose through her bedroom window because her husband kept her trapped in her bedroom and basically wouldn't let her leave, took away her car. She couldn't leave the house, and she could only speak to me through her bedroom window. He would not take her to the doctor because the copay, $35, was too expensive. I tried for many, many months to convince Rose to leave. She had tried to go to a shelter, and the women's shelter was full, so they sent her to Salvation Army, which was filled with people that she felt were scary, and she ended up going back to her husband. At the end of that, she ended up dying because she didn't get medical care that she needed because her husband wouldn't take her. So that would be an example of abuse or potentially violence, right? I can generate those examples. If you have other examples, I'm welcome to hear that. It gets hard to define some of that for sure, and saying violent crime makes it easy and it's better than nothing, right? It's better than nothing at all. But I would definitely support, as long as we could find that language, support good language that describes domestic abuse and capture that. Absolutely.
Any other questions? Seeing none, thank you.
Thank you.
Attorney Stephen Enders?
Good afternoon, Chairman, members of the committee. My name is Stephen Enders. I'm an assistant county attorney in Merrimack County. I've been a prosecutor for over 20 years. I was also on the subcommittee that wrote this language. And one of the things that almost all attorneys will universally tell you if you say, I feel like I might be getting involved in some type of court case, is they're going to tell you document everything. Write down what's going on, write down when you have phone calls, write down the contents of those phone calls. Because really, when it comes to court, you're going to want to be able to recall exactly what happened, explain exactly what happened, and demonstrate to the court that you know exactly what happened. So now in 2025, pretty much all of us are carrying a high quality video camera around with us at all times, or if we don't have it with us, it's generally within like 3 or 4 feet of where we are at all times. So it certainly makes sense that if you're trying to document what's going on and you've got this high quality video camera with you, you're going to use it to document what's going on so that you can show your attorney, you can show the judge, you can show everybody exactly what happened. The difficulty comes in that there's a wiretap statute in New Hampshire. And unfortunately, the wiretap statute was written in 1969. And as you can imagine, technology between 1969 and now has changed dramatically. When you look at the wiretap statute, they talk about things that a lot of people now don't even understand what they mean. Like when you talk about the operator of a switchboard being exempt from the wiretap statute. I mean, I'm old enough to remember some of the television shows where, you know, there's the operator on the switchboard plugging in the phone lines and listening in on telephone calls. That's not illegal under the wiretap statute. The difficulty, though, is that recording oral communications is illegal under the wiretap statute. So it's not the video portion that's the problem. It's the audio associated with the video recording that's the problem. So the difficulty is that in a lot of cases, we tell people, document everything that's going on. The police tell people, document everything that's going on. And people do that. They make recordings, they bring the recordings into court. And the difficulty is that under the current wiretap statute, there's a question of whether or not making those recordings is legal. So we came up with this language, which would be an exemption to the wiretap statute. And starting from line 3, where it talks about any person except a law enforcement officer acting in their official capacity. The reason that we wrote that language is we started out with any person could do this. And then we thought, well, the problem is that's an exemption that swallows everything, because we don't want law enforcement to be able to go out and surreptitiously record people without warrants. You know, like we don't want that. So we put in any person except law enforcement. But then we realized that, you know, a law enforcement officer, when they're off duty, may be the victim of domestic violence. So that's why we added in that language, any person except a law enforcement officer acting in their official capacity can make or possess a recording when that recording is provided to a law enforcement agency. And we thought, well, if you're making it with the intent to provide it to law enforcement, that's great. And that's why we added that language. Well, then we heard from a lot of the civil attorneys on the committee, and they were saying, well, what if we have a victim who is involved in a civil case but doesn't want to go forward criminally, or is involved in a divorce case but doesn't want to go forward criminally? Which is why we added in that language, are utilized for the purposes of court proceedings. I can tell you that we didn't have the discussion about if it's exempt under this, can you put it on social media? That wasn't a discussion that the committee had. But certainly I think if you did write is exclusively provided to law enforcement or utilized for the purpose of court proceedings, that solves that fear or that concern. The next language, line 7, is or contains evidence of what the person reasonably believes to be a crime. We came out with that language, what the person reasonably believes to be a crime, because we were concerned that there's a lot of things colloquially said. For example, people say, so-and-so is harassing me, or so-and-so is stalking me, or so-and-so is threatening me. And those are all crimes under New Hampshire law, harassment, threatening, but all those crimes have elements. And we didn't want someone to have to say, well, does it actually meet the elements of the crime? We figured that if a person felt that they were reasonably felt like they were being harassed or threatened in a way that they felt violated the law, they would be able to record it. And we didn't want it to be a nitpicky thing where like, oh, you didn't completely meet the elements of harassment, therefore you don't fit in this exception. We also, we did start out with this just being contains or evidence of what the person reasonably believes to be domestic violence. But the difficulty is this certainly comes up in domestic violence cases, but it comes up in other cases as well. And I say that because I had a case where we had a neighbor dispute. These two neighbors are arguing with each other, and they go to the police, and the police give them the advice that I said earlier, which is document everything. So one of the neighbors is walking the property line, and he sees his other neighbor who starts coming toward him, and he's actually sitting in his car, and he takes out his phone, and he's holding it in a way that the other neighbor can't necessarily see it. And we have a recording of the other neighbor coming over to his open car window and punching him repeatedly, or punching him through the window. And unfortunately, we got a motion to suppress that recording, and the judge granted the motion to suppress under the current wiretap statute and said, essentially, you know, it's a shame that I have to suppress this because the jury should be able to see this video. This should be part of the trial, but because this runs afoul of the wiretap statute, I can't let it in. So we felt that we didn't want to limit this specifically to crimes of domestic violence, that if there was a neighbor dispute, if essentially you were walking down the street and someone came up behind you yelling, "I'm going to murder you," you could take out your phone and start recording that and not run afoul of the wiretap statute. So I would urge you to pass this language. I'm happy to answer any questions they may have.
Are there any questions for Representative McFarland?
Thank you, Mr. Chairman. Thank you for your testimony, and it's very helpful context. You explained why you contemplated these particular exemptions. You will know, of course, that the statute also contains an exemption for law enforcement officers to make body-worn recordings.
Yes.
If you know that private citizens in their vehicles and from time to time on their persons seek to use those kind of video camera and audio recording mechanisms to preserve and document evidence, what's your point of view on whether there should be an exemption for either a body-worn recording device or a car-borne recording device?
So normally with like a dash cam, there's not an audio outside of the vehicle necessarily. Where the other thing is, when you start looking at the definitions in the wiretapping statute, oral communication is defined as any verbal communication uttered by a person who has a reasonable expectation that the communication is not subject to interception under circumstances justifying that expectation. So, for example, if you pulled out your phone right now and started recording me, that wouldn't be a crime, because I have no reasonable expectation that the proceedings right now are not being subject to intercept. In fact, the opposite. I know that they're being broadcast on YouTube or whatever it is. So with reference to body-worn cameras, I think that the exception that was put in the wiretap statute for body-worn cameras was just to be extra safe. Law enforcement officers have to be in uniform wearing body-worn cameras. They have to let the person know by statute through 105D2 that they're being recorded. So I don't think you can necessarily make the argument that I had no idea I was being recorded by a police officer who's wearing this obvious camera on their uniform and telling me I'm being recorded. In terms of, I don't know that we necessarily have non-law enforcement officers utilizing body-worn cameras, but if a person decided to take a GoPro and strap it to their chest and walk around, I don't think that's a crime, because if I see a person with a GoPro on their chest, I don't have a reasonable expectation that I'm not being recorded at that point.
Thank you.
Thank you.
Representative Tur?
Yeah, thank you, and thanks for taking the question. I just want to clarify, is it your sort of testimony that this would be reasonable to expand to just all violent crimes? Is that sort of a reasonable modification of this to cover domestic violence and then any other, and I don't know whether the term violent crime needs to be defined, but that's really the question.
I think as it's written right now, it covers all crime, whether it's domestic violence, whether it's violent crime, or whether it's just crime in general, because we use in line 7, that paragraph 2, evidence that of what the person reasonably believes to be a crime. So, I mean, I guess theoretically, if I was in a car with someone who was speeding or driving in a manner that I thought was reckless, and I felt that I wanted to record that surreptitiously and provide it to the police as evidence, this would cover me under as an exception.
Okay, so you think it's already even broader than violent crime? It really covers all.
I do. I think it covers all crime, and for me personally, I think that's appropriate because I don't want to start parsing out what crime you can record and what crime you can't record.
Representative Morton.
Thank you, Chairman, and thank you for this question. Where do like Ring or Nest, those types of camera systems or similar things come into play? Because obviously you walk up to a house, you can see it, but not necessarily. Somebody might have like vines growing up or whatever, and you don't necessarily see the camera. Where does that fall? Is that a gray area?
I think that is a gray area. Again, I would go back to that definition of oral communication. I don't know that in 2025, I could have a reasonable expectation that I'm not being subject to intercepts standing on someone's front porch, because there is such a proliferation of Ring cameras and that type of thing. And again, the difficulty is that the wiretap statute written in 1969 and a lot of the things within it aren't necessarily applicable to the modern world that we live in now. And I can tell you, one of the concerns I personally have is if you yell, "Hey Siri," loud enough, half the phones in the room click, because those phones are listening into our conversations at all times.
Mine just did.
Yes. So, I mean, I had a conversation with another attorney in my office. We were talking about this statute, and I said, "Well, what about right now? Do you think we're being subject to interception?" He's like, "Well, absolutely not." And I yelled, "Hey Siri, do I need a raincoat?" And my phone goes, "Beep beep. No, it's not raining today." And I'm like, "See, that we're being intercepted right now." So I think that the entire wiretap statute, is due for a 2025 update. I think that's a monumentally large task, though. I can tell you this: the wiretap statute as it exists now is copied almost 100% from the federal law and still exists.
Who asked for follow-up? All right. Morton, you asked for follow-up? No. Representative Tripp?
Thank you, Chairman. Thank you for taking my question. It's interesting that when you read the wiretap law, it only had to deal with audio recordings, I believe. It didn't have anything to do with video recordings.
Correct.
Does this law do anything with regards to permitting videos to be recorded? And
so it wouldn't affect video at all, because again, the wiretap statute is only audio recordings. So I can theoretically surreptitiously videotape someone, unless they're in like a locker room or that type of thing, where you end up with a violation of privacy violation. But if I just was videotaping with no audio, you wouldn't run afoul of the wiretap statute.
Thank you.
Representative Manos?
Thank you, Mr. Chair, and thank you for taking my question. I'm wondering about exculpatory evidence and whether this bill would implicitly create a right on the part of the other person to the interaction to record for purposes of exculpatory evidence.
It would create an exception to record to give to law enforcement for the purposes in the bill. If that were, I guess, if I understand your question, you're asking if the person that we're considering the batterer in the relationship decides to record and they provide that recording to law enforcement, I think that would be a legal recording, because they could certainly make the argument that they reasonably believed that they're filming the crime of perhaps false report or that type of thing. So I do think that it goes both ways in terms of everyone recording.
Representative McFarland.
Thank you, Mr. Chairman. I was going to ask a different question, which I'm still interested by, but I think the more important one. You're asserting that the RSA Chapter 570A that we're discussing here is focused on voice.
Correct.
And can you explain then, while I understand that the oral communication definition in that chapter aligns with what you're saying, if I know that the definition of telecommunication is the transfer of any form of information in whole or in part through the facilities of a communications common carrier, and goes on, does it not in fact cover only audio communications in person, without the use of a common communications carrier? But as soon as you start to involve a communications carrier, it can extend to data and video and voice and all manner of information.
So the telecommunication part of this does in fact go beyond, does have data involved in it. However, if you're intercepting a telecommunication, that's different than filming something that's occurring live. So if I'm filming something that's occurring live, I'm not intercepting a telecommunication. If I'm able to, somehow get up on a telephone pole and put some alligator clips on the wire, or, take these cell phone signals and somehow capture them and pull them in and descramble them and understand them, I'm intercepting a telecommunication. That's not where we normally see the wiretap statute being violated now. Where we see it being violated is the acquisition of oral communication. So it's the people talking, that type of thing, because the telecommunication part really requires a level of sophistication that we don't generally see now.
Very quick follow-up, if I may.
Follow-up?
Would you agree that if I was simply to take my cell phone and video record a Zoom, that would include capturing the video data as part of telecommunication as defined here?
I don't believe it would, because I don't think that you are getting the information in whole or in part through the facilities of a communications common carrier. Just like recording a phone call, I don't think is an interception of a telecommunication. If I hold a tape recorder up to the phone, I think I'm intercepting an oral communication, whereas I don't think I'm intercepting a telecommunication unless I'm taking it from the common carrier, if that makes sense.
Thank you.
Any other questions? Representative Morton?
Yeah, so I have a question in terms of state by state. I think Representative Reed mentioned Tennessee was another state that has already passed this. How many other states have passed something like this?
That I'm not sure about. I know that there was a comment earlier about there's a majority of states are one-party states, in the sense that I'm being told from the audience 38 states are one-party states, meaning that if one person is aware of the recording, then the recording is legal.
Any other questions? Representative Turer?
Yeah, thanks. And thanks for taking the question. I don't want to over specify things in the public hearing, but this question about modifying the bill to make it clear that this should be used only for the purposes of legal proceedings. The language that was proposed a few minutes ago is maybe solely, and I'm worried about that concept in terms of if someone shares it with a family member, if someone shares it with their legal counsel, or if someone, would you think that prohibiting public disclosure or knowing public disclosure would be a better approach? And we can talk about language separately, but I just was wondering what your thoughts were.
And that is something that we had discussed in the subcommittee, is providing it to your attorney, providing it maybe to a support system within your family. And again, we never addressed the concern of sort of simultaneously posting it on social media. That didn't come up. So I'm not sure what the best way to word that would be. Because again, we did want to leave it broad. If you reasonably believe you're the victim of a crime and you're recording it with the intent to give it to the police or use it in court, we wanted that to be the exception.
Thank you. Any other questions, Representative Tripp?
Thank you, Mr. Chair. Thank you for taking my question. So, if I was to make a video recording of a domestic abuse situation and I was to mute the audio, would it be against the law to put that on social media?
No law that I'm aware of.
Thank you.
Any other questions? Seeing none, thank you.
Thank you.
Dave Suckling?
I assume the red light means I'm good to go.
You're good to go.
My body camera's not running, just so everyone's aware. Thank you for having me today. I was totally unprepared for this. I came in for another bill and sat down and read this and heard the testimony and thought I'd chime in. So bear with me as I fumble through this. I'm a chief of police in the town of Alexandria. We have 1,600 residents and 2 police officers, so I'm half of the department. When I say that we're busy, we're incredibly busy. We arrest around 10% of the population every year. And that's about 160 arrests. And a lot of them are domestic violence. I've been through 2 police academies and I had countless hours of training on domestic violence and the relationship between an abuser and abused. We're often told that domestic violence is about power and control and the relationship between the power and control. And we arrive at a domestic violence situation, and quite often they're very complex and they're very hard to understand when we're there at the last moment. These are very complex cases for us sometimes. Sometimes they're very obvious, but to understand the relationship between an abused and abuser can be very, very tricky. They're often exigent. We're looking to deal with this then and there, rather than a prolonged investigation, because victims deserve that. They deserve that justice, and potentially it could be a life-saving arrest if we left without it. I would welcome any tool that we could to help with the prosecution of domestic violence, and also understanding during our investigation with any kind of information that we can get to help with that investigation. I support this bill, and as law enforcement, we want to get it right. Every opportunity that we can, we want to get it right. We don't want to arrest the wrong person. This is a very narrow exception to the wiretapping statute, and I think we deserve it, and I think as law enforcement, we would benefit from it greatly. I'm pretty unprepared, but I'll take any questions if you've got them.
Seeing none, thank you.
Thanks for having me.
That's the last pink card I have for House Bill 587. Is there anyone else that wants to speak on this bill? Seeing none, I'm going to close the hearing on House Bill 587. And we're at that time for 593. So I'm going to open up the hearing on House Bill 593 and recognize Representative Ellen Reed to introduce the bill.
Thank you again, Mr. Chair, and thank you once again, honorable members of the committee. My name is Ellen Reed. For the record, I represent Rockingham 10, which is Newmarket, in new fields. This bill concerns loss of consortium, which is something we already have in our statute, as the vast majority of states do have. The history of loss of consortium is honestly, it's creepy. It comes out of hundreds of years ago in England, when the idea was if you killed a woman's husband, you're denying her monetary benefit, but there was no, if you killed a wife, you weren't denying the man anything monetary, but you were denying him consortium, his consort. And so it got created many years ago, hundreds of years ago, as this like right of action, essentially, for men who were losing their consort. However, it has been expanded in this country to include certainly the loss of a spouse, the emotional damage you experience when you lose a spouse. And that's pretty much universal across the country. Most states include a loss of a child. We do not include the loss of a child. In fact, we don't really define loss of consortium at all in our current loss of consortium statute. This bill does give a definition. I'm happy if the committee wants to rework that definition, but I think it's prudent at the very least to define our current loss of consortium. 5 states, at last I knew as of last year, extend loss of consortium in some capacity, some ability to go after emotional damages for the loss of a pet. I think the obvious argument is currently in our law in these states, and I should read the states, these states have decided that the current situation we have in New Hampshire is not sufficient, because in our law right now, if you have a dog or a cat and I kill your dog or cat, either maliciously or negligently, the only thing you can go after me for is the replacement value of that animal, a couple $100s or whatever. You cannot go after the actual damages that I have done to you, which is denying you that particular animal, your companion. I think we all broadly know that our animals are worth more than their replacement value, that they are our specific pets. They are members of our family and we love them. And it's a lot more damaging than just the cost of a new puppy if someone were to brutally kill our pet. So these 5 states have seen that as an issue and have addressed it. Illinois, Maryland, Connecticut, Nevada, and Tennessee. There's my home state again. Home state leading the way. So here I have included, this is based on a bill prior sponsored by the Honorable Dan Hines, who introduced this last year. Loss of consortium means the loss of love, companionship, comfort, care, assistance, protection, affection, society, and moral support of a spouse or pet, the loss of the enjoyment of sexual relations with a spouse, or the loss of the ability to have children with a spouse. So this would cover a wide range of damages, including like if you were to maim or permanently disable a spouse. This is pretty consistent with how it's used across the country. But that simply adds definition to paragraph 2, which is the current law, that's existing law. Then paragraph 3 extends that to pets. So one of the things I included in paragraph 3 is the specific covering of when an animal is killed by an officer. And the reason I had to do that is because a number of years ago, there was a court case in the state where a judge, it did not go all the way to the Supreme Court, but a judge had found that the owners of a dog that had been killed by an off-duty officer, negligently killed by an off-duty officer, did not have a right to claim a negligent emotional damage against that officer. And because of that, and because there seems to be a lot of attention given to law enforcement officers who have killed people's pets, either certainly there is a reason to have to do that on occasion, but there's been a lot of attention given to law enforcement officers potentially needlessly killing people's pets. And so because of that, I have made sure to explicitly include law enforcement officers are not exempt from this. So I think the purpose, the intent here is really obvious to kind of state that our pets are not simply property. It's not like a vase, a table, a chair. it means much more to us than a pet means much more to us than simple property. I realize that last year and likely this year, the opposition against this bill is mostly comprised of a couple different organizations. The first would be breeders and breeding organizations. They have a direct financial interest in saying that animals are only property and not anything more than property. It's very unfortunate and probably counterintuitive that they would want to argue that position, but they definitely want to argue that position and say that this is historically the case. It's always been the case that animals are just property, because they know that as we advance in animal welfare laws, they are no longer allowed to necessarily do whatever they want to animals in the name of profit, whereas if it's property, they are. So that is the kind of position that group has argued from. You may very well hear that today. The other group of opposition to this bill last year, and I expect again this year, are insurance companies, which of course stand to lose a little bit if there is more damages in a civil action. If you have you're now not just on the hook for the $200 dog that you killed, but you're on the hook for maybe $5,000 of emotional damage. An insurance company doesn't want to have to cover that. So that's also a monetary motive to oppose this bill. I will say we do this elsewhere, where insurance companies will have to cover things. For example, malpractice. We have malpractice laws. We don't get rid of our malpractice just because insurance companies don't like having to pay. So we do enshrine rights of action when people are being damaged. In fact, all of civil action, the purpose of it is to make someone whole. And if we as an entire society acknowledge that our animal, simply replacing a replacement value on an animal does not make the owner whole, because you did lots of damage to that person by taking away and brutally hurting their animal, then we are not doing the intent of civil action, because we're not allowing people to be made whole. I would just end with saying the sky is not falling if we have this right of action that we extend to pets. The previous bill did extend it also to children. The conversation around that got very, I think, muddy and confusing, and so I did not do that, but it does make sense, and I do support that concept of doing, I think it's 33 other states extend it to children. So having said that, it's okay. We can actually reflect our values in the law and allow people to be made whole when their pet is killed, and I will be happy to take questions.
Any questions, Representative McFarland?
Thank you, Mr. Chairman. Your bill defines loss of consortium, and I think defines it in a different way than the courts historically have understood it. As part of that definition, it refers to a pet. Where is pet defined? How should it be defined?
Thank you for the question. So you raise a good point. Anytime, as you know, a word is not defined in statute, the courts go to the Merriam-Webster third edition, and I would suggest that that is the definition. Having said that, it really becomes an issue of, did your pet tarantula give you the same emotional benefit that your, 18-year-old golden retriever did, or what have you? And it becomes subjective. And a lot of court cases end up being subjective. Last time this came through, there was discussion on amending it to include minimums, maximums, perhaps no more than $10,000, perhaps no less than some amount. That would be a prudent way to go forward to make sure that people aren't like claiming their earthworm was, a loss of emotional damage. You could also go about trying to define the word pet, or strike the word pet and replace something very specific: dog, cat, horse, whatever. Maybe I think you get kind of messy, and I think it's kind of at that point, as we typically do with our intentional ambiguity in law, it's best left to the judges at that point. But if you have a good definition, I'm happy to hear it. I think the whole intent is to go forward with saying that our animal companions are worth more than just replacement value. This particular definition that I'm using here is based on last year's bill.
Follow up?
Follow up.
So You've already indicated that you have an understanding of some of the opposition's points of view from the prior testimony. We have in front of us written testimony from the American Kennel Club and from the dog owners of the Granite State, and I imagine we'll be hearing from at least one of those organizations presently.
I imagine.
In your understanding, you started talking about this and I didn't quite follow. What do you perceive to be their motivation? Is it the fact that the language here doesn't speak to ownership of the pet, or is it something else?
Oh no, based on not just testimony from last year's version of this bill, but based on the testimony and various bills from those organizations, my understanding of their opposition to the concept in general is that they very much are invested in the idea that an animal is only ever property like a table, a chair, a car, that it has no value beyond that, because that enables them to make money without a lot of answering to what they are afraid of would be future animal welfare legislation. And an example of that is...
I think we're
Yes,
going to
Mr.
hear
Chair.
from them what their motivation is.
Sure, I'm just answering the representative's question. He was
You
asking
discussed
my
it earlier, I gave
perception.
you some leeway, but interpreting their motivation as opposed to us hearing from them directly, I think that's probably a better.
I appreciate the point, Mr. Chair, is answering the representative's question.
Any other questions? Seeing none, thank you.
Thank you.
Stacy Ober?
Good afternoon. Thank you, Mr. Chairman, honorable members of the Judiciary Committee. My name is Stacy Ober. I am the New England Government Relations Manager for the American Kennel Club. And you may or may not know that we are a 140-year-old animal welfare organization, a nonprofit club of clubs. We're a recognized expert in canine health, breeding, training, and responsible dog ownership. We have more than 5,000 clubs across the country, including 13 here in New Hampshire. That represents hundreds of dog owners who are passionate about their dogs. I wanted to acknowledge that House 593 would expand the relationship eligible for potential loss of consortium damages to include individuals' relationships with their pets. And as you heard from the bill sponsor, this concept was included in House Bill 1684 last year and rejected by this committee. We know that people do experience real grief upon the loss of a pet, and AKC established 5 years ago an online pet loss group that has more than 13,000 individual members. There's little doubt that dogs are held in exceedingly high esteem throughout modern American society. But the American Kennel Club is an animal welfare organization, not an animal rights organization. So I wanted to take a moment and just make the distinction between the two. There are many organizations that philosophically, their position is to oppose the use of animals by humans and advocate for changes in law that would imply animals have the same legal status as humans. And an example of that would be not allowing working dogs, whether that be police canine, livestock, guardian dogs, therapy dogs, that unless a dog provides its consent, it should not be used in a working function, for instance. Animal welfare organizations focus on improving the quality of life for animals. We support the use of animals such as working dogs, police canines. Our clubs have contributed under the Adopt a Canine Cop to police dogs to New Hampshire towns, for instance. We seek to minimize suffering and disease. Our Canine Health Foundation has funded more than $68 million in canine health research that has benefited all dogs, and promoting responsible care, proper housing, nutrition for animals. And we have in place a long-standing legal framework that actually supports those goals, which is why we're concerned about this particular bill. The legal framework holds owners accountable for providing proper housing and nutrition. That's why it's how our animal cruelty laws are able to be enforced. And And we also use the legal term pets as personal property because if animals are stolen, for instance, the legal system allows for the return of stolen property. So those are some examples as to how the legal framework has worked. I've submitted written testimony and just wanted to acknowledge that our concerns in adding non-economic damages for the loss of a pet could result in an implied change of the legal status of animals that would in the long term really create unintended but very negative consequences for that. And I can elaborate and give examples if that's helpful to the committee.
Okay, any questions? Representative McFarland?
So I've read through your written testimony as well as heard what you said, and I very much appreciate that. I guess in trying to understand a bit more about the negative consequences that you foresee, I certainly I look at this language of this bill and I see a number of areas of concern, but can you help me understand, for example, if I think to a squirrel in New York called Peanut who was recently murdered by law enforcement, do you believe that there is justification for there to be a better cause of action in our statutes against that kind of an event, and a better cause of action for the pet's owner to recover damages?
I think the law it purposely should acknowledge when there is emotional distress, and there are tort avenues for the infliction of emotional distress, for instance. But in terms of loss of consortium, this particular bill is equating a pet with the same relationship as a spouse. The sponsor noted, for instance, that New Hampshire law does not allow loss of consortium even for, let's say, a child who loses a parent. And so from our vantage point, the ultimate goal of these incremental changes is to create statutory language that would suggest that pets are of the same legal status as humans. And our concern about that is, for instance, let's say you have a veterinarian that performs surgery on your pet, and there's an unfortunate outcome because just like medical care, nothing is absolute. In that instance, the court, were this to pass, would have to come up with a subjective determination as to the level of emotional grief that the owner or family suffered. Our concern is that veterinary medicine would resort to defensive practices in terms of having to perform every test or every procedure for fear of being sued in the event they misdiagnosed or there's some other unfortunate outcome for a pet. And that those kinds of lawsuits are an incentive for attorneys to bring cases forward, that in the long run it could increase the cost of veterinary care, making it more difficult for people to access veterinary care from an affordable standpoint. And it's another example of the long-term negative consequence we believe, including non-economic damages in the loss of a pet, would result in. I hope that's helpful.
Any other questions? Seeing none, thank you. One more card. That goes. Was there someone else who wanted to speak on this? Oh, you have your pink card with you? And somebody else turned one in already? Yes, you can come on up and just state your name. Okay. I gotta locate it here. I may have turned it in already to you.
Oh, sure. Who is it?
I'm not sure. I'm gonna find out in a second.
Just take me a second. I ran out of hurry quite a while ago.
Oh, there they are. Gotta be here.
You'll note that the testimony I'm handing in has both sides. I printed out both sides and
Okay.
just trying to save a little bit of paper. Okay, Mr. Chairman and members of the Judiciary Committee, my name's Nancy Holmes. I'm from New Boston, New Hampshire. I'm opposing the changes proposed in HB 593. Just for a little background, yes, I have been a breeder. Yes, I have been an animal rescuer. I've studied animals all my life, and I spent some time, 5 or 6 years online as the top animal expert on a website. I got looking at this law, and I like to look at the original law just to see if I can figure out what its intent was. If you look at 5078A, loss of consortium, you will see that it only applies to a husband or wife and no other family member. I believe this is because loss of consortium between husbands and wives includes sexual relations in all common interpretations of the term loss of consortium. If you look at I included a little blip from Cornell Law School for an explanation of the loss of consortium laws and how they were developed to be like this. HB 593 includes changes that equate the loss of a pet to the loss of a spouse, a comparison that appears to me to be negated by our laws on bestiality. And believe me, I spent some very uncomfortable hours up here when they were working on the bestiality laws. And despite the supporters' attempt to remove a link to sex in their new definition of consortium, I don't think that's going to hold. However, our law covers claims of children and other close relations for wrongful death damages. They're addressed under RSA 556.12 because RSA 507.8A does not apply to them. I included the law so you can just see it. I hate having to look stuff up, so I just threw it in. And you get down to 3D, it says, for the purpose of this paragraph, loss of familial relationship shall include the loss of comfort, society, affection, guidance, and companionship of the deceased. And then it gives a massive amount of award that is possible, the highest amount that's possible. As you can see, children will be eligible to have claims made for them under our wrongful death laws, and I believe parents are covered there too, in the under 556.12, but not under 507.7D. Some might believe that the wrongful death statute more closely is equated to the loss of a pet, except that under our laws, animals are property and are not humans or persons. Thus, I do not believe even the wrongful death statutes apply to the loss of an animal, no matter how beloved that animal is. And believe me, I'm somebody who really loves their animals. And I've been an animal person my entire life. So while I understand the emotional intent of this bill, I believe the bill is wrong-minded. And I think it should be voted as ITL, as incompatible with our current statutes protecting spouses and children, and also with the common legal definitions of loss of consortium. I believe, as I believe it was Stacy said, that our current laws all are oriented to the fact that animals are property, and we have all kinds of laws to make sure they are cared for properly and that and so on. It doesn't make sense to me to suddenly change them into people in this bill, because that would ruin everything else we have done for animal welfare causes in this state. So I'd be happy to take any questions. I'll see if I can answer them.
Any questions? Seeing none, thank you.
Okay, thank you very much.
Angela Ferrari?
Good afternoon, Chairman, members of the committee. My name is Angela Ferrari, and I am president of Dog Owners of the Granite State. We are a nonprofit organization that was founded in 1991 to represent the interests of all pet owners in New Hampshire. We have a vibrant community from kennel clubs, dog owners, breeders, and fanciers across the board. I would like to focus my testimony. I did submit written testimony, but I'm going to veer a bit from it and focus more on the ownership rights that were mentioned during the opening introduction of today's bill. So we feel that it's crucial to prevent pets from being included in loss of consortium laws because doing so would fundamentally alter their legal status, setting a dangerous precedent that could strip away owners' rights and create unintended legal consequences. Some examples: changing pets as property undermines ownership rights. Under current law, pets are personal property similar to a car or a home, and owners have full rights over their animals, including decisions about their care, training, and even euthanasia when necessary. By granting loss of consortium claims for pets, they are no longer treated as property, but instead as something closer to a legal person, potentially limiting what owners can do with their own animals. This shift could open the door to government overreach, where lawmakers or courts could dictate how to care for, sell, or even breed your own animals. Loss of consortium expands legal standing, so we want to ask the question, who can sue? If pets are granted loss of consortium protections, who has the right to sue? Could a shelter, a previous owner, or even an activist group claim a legal interest in your pet's well-being? This could lead to legal battles over custody, decision-making rights, and even restrictions to pet ownership, similar to child custody cases. It also creates a pathway for pet guardianship over ownership. So animal rights activists have long pushed for replacing pet owner with pet guardian in legal definitions. And loss of consortium applies to pets, it moves us closer to a system where pets have legal standing, meaning courts, not owners, could have a say in their care. This could eventually mean you would no longer own your pet, but instead manage them under state or federal regulations, reducing your rights. We feel it opens the door to frivolous lawsuits. Allowing emotional damages for pets could flood the legal system with expensive, subjective claims. If someone accidentally harms a pet, whether a veterinarian or a groomer, as mentioned in Ms. Ober's testimony from the AKC, they could face massive lawsuits for emotional distress. Businesses, municipalities, and individuals would face enormous liability risks, potentially leading to higher costs for veterinary care and even home insurance. Also want to mention the slippery slope and what comes next from this type of law. If pets get legal rights to loss of consortium, what could follow? Could service animals, farm animals, or even AI companionship devices or heirlooms from your family members gain similar legal recognition? Would animal activists then push for restrictions on pet breeding, training, or even ownership itself? This sets a precedent that could erode human rights over property and blur the line between pets and legal persons. Protecting owners' rights means keeping pets as property. So we would ask that you would ITL HB 539, and I would answer any questions.
Any questions? Seeing none, thank you.
Thank you.
Shauna, is it Silver?
Hi, my name is Shauna Silver, and I requested this bill after the wrongful death of our dog Daisy. I've since started therapy after watching her suffer, and I'm also working on filing a vet board complaint. As mentioned before, there are 5 states that have adopted modest laws that provide some level of damages beyond market value, like emotional distress and loss of companionship. Illinois and Tennessee specifically allowing consortium for pet loss. New York also recently introduced a bill for paid time off in the event of your pet's illness, injury, or death. These states are recognizing the bond emotional dependency, mobility, assistance, companionship, and love that our pets bring into our lives and the loss of it. For many elderly or disabled people like myself, this is just amplified because sometimes this is like the only socialization that you get on a day-to-day basis, especially if you're confined to your home. Virginia courts have recognized the bond between humans and pets similar to one of a parent and a child, and that the loss can be equal to the loss of a human family member. Comparing a living being with the intelligence of up to a 3-year-old to a random piece of property is outdated, as millions of people consider them family. Consortium does not give legal rights to animals, but asks the state and the law to recognize the importance, reality, and the bond of and the health benefits that the animal gave to that human, and to recognize a new action for the wrongful killing of that pet. Allowing animal consortium transforms their status into living property, giving owners cause of action and recognizing the harm caused to the owner mentally, emotionally, and physically. I'll use myself as an example. I have ongoing panic attacks and I've lost 15 pounds since her death. If New Hampshire allowed consortium, there's no guarantee that the judge would still award it. It's just giving people the option to ask for it. On Tennessee law, review.org/animal consortium. It goes into detail on how consortium has expanded when it first started, and women were also legally viewed as property but now allowed consortium, and it expanded again, allowing other family members and now pets to be covered under the consortium umbrella. The document also goes into detail on a scientific study called Bowlby's attachment theory, proving that the human to animal bond is just as significant as a human to human bond, and it gives many examples of this. It also goes into in-depth detail of all the positive health benefits of the human companion animal bond. Laws change all the time. People weren't able to list their pets as a beneficiary on their estate or trust before 1990, and now you can. And as of 2016, 32 states now allow animals to be included in protective orders. New Hampshire is also starting to recognize pets as living beings versus property. Like in family law, they rule for the best interests of the pet. And during states of emergency, you can now bring your pet to emergency shelters. I hope the state of New Hampshire will join these states and show compassion for the owners whose pets were wrongfully killed, as they were also the victim of trauma and mental anguish, especially in cases involving professionals who failed to uphold the standard duty of care, like in Daisy's case. I hope that New Hampshire can come to a fair compromise on this bill, like how other states allow non-economic damages and/or consortium, but also have a maximum limit on what you can claim and other restrictions, so people can't abuse it. And I do know that the AKC, opposed it because they were worried about the safety and insurance going up. But I think that this bill would actually limit incidents and wrongful deaths, because with a higher consequence hanging above the professionals' heads, they would pay more attention and less incidents would occur. Like with driving, if you're a safer driver, you're going to have lower insurance, and animal hospitals already have liability insurance, so that would most likely cover this, especially if you put a limit on how much people could ask for. And upselling exploratory testing before diagnostic testing is being seen more and more, according to the medical expert witness that I spoke with regarding Daisy's situation. And this, along with a vet tech going against vet's orders and withholding her medicine later to call it in and still never do it. Incidents like this are currently hurting animals. Medical issues that could easily be identified and treated are being overlooked. This is hurting animals. I would like New Hampshire to please look into the states that do allow this and see that liability and is not going up, and animals are not getting hurt because of this, because of the restrictions, and because it would be up to the judge's discretion. And yeah, I'm not really so sure about why the AKC thinks that this would be harmful, when according to the Humane Society, they actually opposed a lot of bills that were targeted at protecting animals, like stopping puppy mills and animal fighting. And again, this law would be aimed at the human and the loss of that relationship. Thank you. Is there any questions?
Any questions at all? Seeing none, thank you. And do you have some written testimony that you want to turn in, or?
Yeah, okay.
If you, even if it's one, we can give to the clerk if you want to. Thank you. I don't have any more pink cards for this bill. Is there anyone else that wants to speak on this bill that hasn't? Okay, I'm going to close the hearing on House Bill 593. And we have 6 minutes before the next one. Thank you.
Okay. Good afternoon. Thank you, Mr. Chairman. Thank you to this committee. This is very exciting. This is my first bill, so I'm really thrilled to be here. So HB 462 is a bill that I filed after learning about a situation in my town. I represent Merrimack County 8, which is the towns of Henniker, Bradford, and Warner. So someone in a neighborhood had talked to, Henniker's a small town, everyone knows everybody, and someone had complained about their neighbor putting a camera directly on their property line and watching their backyard. And they have a daughter who's the same age as a late teenage daughter, and they have a pool. It was just really uncomfortable, and I reached out to them because I was going to learn more, and as I did, I asked them if they went to the police in our town, and they said they did, and that the police said that there was nothing they could do about it. And I went to the home, and I wanted to see it for myself and see how it was put in, and that's why I have this diagram for you. So I'm just giving you the backstory of how this came to be. So the camera is very far away from the second house. It's on a post, a wooden post, right on the property line, looking right into the backyard. So I was surprised that the police couldn't do anything about it. And I met with our police chief. His name is Chief Matt French. And he concurred that there was nothing that they could do. It wasn't violating any laws because it was on their own property. So I did some research and found some similar laws that have a cause of action option from other states. New York State was another one, a close one. And I went back and talked to our chief, and he thought it was a great idea to submit this bill. So if you look at the online support of this bill, Chief Matt French did support it, and also our Senator Dan Innes gave support, and I did talk to him about it. So I was grateful for him to sign on as a co-sponsor. So yeah, this will help give folks an option, whereas now they have no option to deal with some sort of perceived violation of someone videoing them directly in their backyard. It's specifically backyard is in the language. So, and that's all I have to say. And if any questions?
Any questions, Rep. Chura?
Thanks, and thanks for the question. It was specifically the inclusion of backyard that I was wondering about, and I guess good segue from our last conversation, but you know, we now have cell phone cameras that can, you know, zoom in 20x, you know, would it be sort of any recording of your home by somebody? I mean, you could zoom in on someone's window and watch everything that's going on if you have access to the front of the house, I guess is my question.
So that actually, zooming into someone's window is actually covered under 644, RSA 644. So, and then it's specific to the backyard because people do perceive their backyard to be their space to have recreation and hang out, go in their pool, do the different things. Everyone has Ring cameras nowadays, so that sort of takes care of the front. You can't really try to regulate that. But the backyard, and this, you know, I gave my diagram just to show how this is a pretty rural area. So there's no other houses around. So there's really no need for someone to put a camera directly facing into someone's yard, if other than to harass them or make them feel uncomfortable. So they did try to talk to these neighbors themselves directly, and the neighbors said, too bad, we're not breaking the law, we can do what we want. So it was really unfortunate. So
Representative Rombo?
Thank you, and thank you for taking my question. I noticed the language that refers to installing or fixing a video imaging device. I imagine that was distinct from someone standing at that property line filming.
Right.
Can you tell us a little more about that difference, or why choosing to phrase it this way?
I just actually used that language from other bills that I had come across from other states.
Okay.
And
I didn't know if there was if there was specific reason for
No, because I don't think you're going to have someone standing outside for extended periods of time, just videoing in someone's home, in someone's backyard, putting a post there, and so that's always going, and you can view from your home, from the comfort of your laptop back home, is, I think, more invasive
I'm glad you haven't lost your faith yet, but okay. All right. I was just curious if there was a reason for that language choice. Thank you.
Okay.
Representative McFarland?
Thank you, Mr. Chairman. Can you explain why, if you believe in this bill, you also think it's appropriate for us to still permit law enforcement to use these mechanisms to threaten the personal property of another person or harass, annoy, and alarm another person?
I don't necessarily concur that if law enforcement are involved in some sort of surveillance, that is to purposely harass them or annoy them or cause harm to them. So I think police do need to have the ability to do that under circumstances if they perceive illegal activity and whatnot going on. So this is really for civil things.
Follow up?
Quickly, unless you're going to...
So, if that's the case, then can you explain how, in the case of non-law enforcement, you would assess what their intent is?
Well, it wouldn't be up to me to assess. It would be up to the courts to assess. If someone feels that someone is watching them via camera, as in this scenario, and then they talk to their neighbor and their neighbor said, too bad, then now, current state, they don't have any recourse. In the new state, they would have the ability to bring their case forward to a judge in a civil claim and let the judge decide if they were being harassed.
Representative Smith?
Oh, thank you, Mr. Chair. My question was the same as Representative McFarland's, and it's the question of being able to assess motive on the part of somebody else. Could it not be a bird watcher who wants to have a camera in an open area where there's also water, just to see what birds?
I suppose, but they could have put their camera at an angle along the property line if they wanted to watch wildlife and birds versus pointing directly into the backyard at the pool.
Thank you.
Yeah.
Representative Tripp?
Thank you, Mr. Chair. Thank you for taking my question. I got more than one, but let's start with the first one. The camera, I presume that it's mounted on the house number 2's property?
No, it's in the diagram. It's mounted on a post down by the.
Well,
yeah.
But the house number 2's property extends to behind the house number 1?
Correct.
So it's mounted on the house number 2's property.
It's on their property. I thought you meant on their home. No, it's on their property. Correct. On a post on their property.
Follow up?
Quickly, yep.
So the issue at hand is that the camera is used to video the rear of the house number 1.
Correct. That's what's happening. Yes.
One more?
One more. Go ahead.
Okay. So
I think you're getting somewhere here. So.
What?
I think you're getting somewhere.
Yeah, so the has house number 1 given any thought to mounting a floodlight pointed at the video camera?
So this is this is not exactly to scale, but this is a rural area. These are very large guards. So for them to expend money to put in either we talked about a fence. I said, why don't, if you put up a fence or another post with a light, that's still expense. They have to run electric through a long distance to get it out there. It's not a practical thing to try to block that camera that way. Yeah.
Representative Morton?
Would this, thank you. Would this have anything to do with drones?
I don't know if it would apply to drones. It's, I suppose, if the video imaging device
installs or affixes, so
yeah,
it's different.
Yeah, I don't think it proceeds to drones. Yeah.
Representative Manos?
Thank you, Mr. Chair, and thank you for taking my question. Do you happen to know, as you learned about this situation, was the post that the camera is mounted on, was the post put there on purpose to mount the camera to?
Correct. It hadn't been there. So this place, this land where house 2 is, was vacant. It was a lot for sale for a long time and no houses were there. Then it was purchased. A house was built. Then the post was put up with the camera.
So they were done simultaneously? The post was installed for the purpose of holding the camera, mounting the camera?
Yes, yes.
Thank you.
Any other questions? Representative Tura?
Yeah, sorry, another specifics of language, but thanks for your earlier answer on the term backyard. I noticed it says images of the recreational activities, and it also specifies adjoining property. Both of those seem like they kind of provide workarounds for this, in terms of what the activity actually is, and what if it's not adjoining? What if you're going across, another piece of property before you're doing the same exact thing, like a zoom camera, two properties away, but you've got a clear line of sight. So those two questions, just in terms of why those two terms are in the bill. So recreational and adjoining.
I think we'd have to ask OLS because they helped with the language.
Is there a follow-up?
Yeah, go ahead.
I'm sorry. Is there a reason why you would think those words are needed in this bill?
I'm not sure. I'm not an attorney, so I don't know. They recommended it. They put it in, so yeah.
Representative McFarland?
Was this the only video camera on the property of house number 2?
Yes.
Any other questions? Seeing none, thank you.
Thank
And
you.
congratulations for getting through your first one.
Thank you.
Representative Reed?
Thank you once again and for the final time today, Mr. Chair and honorable members. Again, my name is Ellen Reed and I still represent Rockinghamton, Newmarket, and Newfields. I just generally want to affirm my support as a co-sponsor of this bill. I don't know the particulars, have not been to my colleague's district and her constituents' home to observe in person the situation. However, all of our law, not just in the state, but federal law, SCOTUS interpretation of law, including even things like medical law, everything goes back to privacy being a reasonable expectation of privacy. Do you have a reasonable expectation of privacy? If you have a reasonable expectation of privacy, and not to bring into the conversation the bill 2 bills ago on recording instances of domestic violence, but if that's happening in public on the street, you don't need anybody's permission because there's no reasonable expectation of privacy. You can take a video of something happening in the street. We see that all the time on TikTok or what have you. But if it's in an area, like in a room, your bedroom, between 2 people, now you need that 2-party consent, right? Now it's a reasonable expectation of privacy and you need consent. And the question is, do we as a society think that our backyards, not the front yards that are exposed to the public street, but the backyards, do they have a reasonable expectation of privacy? I think we all kind of agree they do. We have a reasonable expectation of privacy behind our property where you can't see from the street. And so now this particular bill does not make it illegal to record, but it provides a private right of action for someone who's doing it to harass or to spy on their neighbor. And I think we all know that that's problematic behavior. So that's kind of, there was another question that got raised, but I didn't manage to write it down before I forgot it. So I'm happy to answer questions, but I just wanted to remind everybody that this is kind of what we've agreed on over case law as a society, both in the state and federally. And also we recently cared so much about that privacy that the state of New Hampshire passed a constitutional amendment reaffirming our privacy.
Representative Tripp?
Thank you for taking my question. Do you, is it safe to presume that the video camera that is installed is capable of recording audio?
Yes, I was kind of going to go down that rabbit hole. So then the question becomes, that's a 0-party consent video, right? Because the person recording isn't even part of that conversation. They're recording other conversations that other people will have. And that is, by definition, spying.
Actually, wiretapping, I believe.
Wiretapping. So apologies. You are the Judiciary Committee, and I stand corrected.
Representative McFarland?
Thank you, Mr. Chairman. How large of a rear end does the parcel need to have before there's an expectation of privacy?
I just love the way you said that. So again, I kind of touched on this on the last bill, where we have intentional ambiguity in language in law because we cannot, predict every single case that could possibly happen. That's why we have the courts to say, yes, this fell under this this intent, this legislative intent. No, this didn't fall under that legislative intent. That's why we have the judges making those determinations. If the committee wanted to say, for it's any area that is not visible from the streets, then you could do that, or you could come up with some other definition or some footage or whatever. But I think the thing that's important here is that we all have a sense that there are parts of our property that are not viewable from the street by the public that we should have a right to expectation to privacy and therefore people should not be wiretapping, spying on us.
Thank you. Any other questions? Seeing none, thank you.
Ellen out. All right.
Henry Gieson, representative.
Thank you, Mr. Chair, honorable committee. I like the premise behind this bill, and I'm reluctant to say that I'm supporting it without certain amendments because of further implications. And the first one is, I want to caution intent versus innocuous viewing. So like my house has a staggered backyard and I have a rear camera. My tenants have a dog that they let out, on my property, etc. But based on the shape of my yard, I have an innocuous viewing of my neighbor's backyard. Now I'm not pointed that way. They're just offset. So motion detector will tell me when they're walking their dog. That's not spying on them. That is overwatching my backyard. And just by virtue of where their house is located, I catch a portion of theirs. So if this isn't worded very carefully to establish intent very smartly, I could be committing a crime just by overviewing my backyard because of the shape of the lots. The second concern that I have is on lines 12 and 13, provisions shall not apply any law enforcement personnel engaged in conduct of their authorized duties. Law enforcement warrants are already covered under a separate code of law, and the law enforcement warrant would not give law enforcement the right to subpoena my camera as a neighbor without, it's like you get into a right to privacy with the neighbors if law enforcement thinks that they can start pulling neighbors' cameras. Or that they can do surveillance from my property. I've actually told a local inspector to get off my property because they parked in my yard watching construction next door because they wanted to catch them doing something. And I don't consent you using my property to spy on my neighbors. So I think that 11 and 12, those lines would need to be struck from this entirely because there's already codified into law what law enforcement has the right to do with warrants. So that's my thoughts on this situation. Thank you for your time.
Any questions? Seeing none, thank you. That's the last card I have for House Bill 462. Is there anyone else here that wants to speak on that bill? Seeing none, I'm going to close the hearing on House Bill 462, and we have a few minutes. open up an executive session on House Bill 593, and I recognize Representative McFarland for a motion.
Thank you, Mr. Chairman. I move in expedient to legislate.
Is there a second?
I'll second that.
Representative Tripp seconds. You want to speak to your motion?
Certainly. Let me just fish the paper out here. It seems to me that while there is some laudable intent in the sponsor's bill, the bill is written in such a fashion as to be unworkable and even simple things, including the lack of definition of a pet, the lack of specification of whether or not the loss of consortium only applies to the owner of the pet or to other parties, the lack of distinction between an intentional death that was with the owner's instruction or intent versus an intentional death by a third party without the owner's instruction or intent, and so on and so forth. And I think we've heard strong testimony from the American Kennel Club and dog owners of the Granite State against it as well.
Thank you. Representative Tripp, do you want to speak to your second?
I remember this bill from last term. It's well intentioned, but I think it has unintended consequences that make it unable to pass.
Any other discussion on the bill? Representative Manos?
Thank you. I support the ITL, but I did want to comment that I greatly appreciated the remarks about at one point in time, women were recognized as being property or chattel of their husbands or fathers, and the concept of ownership of pets may be changing over time. So I agree with the ITL, but I did appreciate those comments. Thank you, Mr.
So
Chair.
noted. Thank you. Any other conversation about it? Seeing none, I ask the clerk to call the roll.
Representative Tripp?
Yes.
Clerk votes yes. Representative McFarland?
Yes.
Representative Morton?
Yes.
Representative Smith?
Yes.
Representative Horgan?
Yes.
Representative Page?
Yes.
Representative Manos?
Yes.
Representative Tur?
Yes.
Representative Rombo?
Yes.
And Chairman Mannion?
Yes.
11 yeas, 0 nays.
Okay, with that, I'll close the executive session. Oh, wait a minute. We have any objection to consent? None? Seeing none, we'll go on consent. Will you write a report on that, please? Thank you. And with that, we're going to close the executive session on House Bill 593. $3:15. order and open up the hearing on House Bill 614 and recognize Representative Cordelli, the prime sponsor, to introduce the bill.
Thank you very much. It's a pleasure to be in Judiciary today. For the record, Glenn Cordelli, representing Tufton Borough, Moulton Borough, and, Tufton Borough, Wolfboro, and Ossipee in the beautiful Lakes region. Thank you very much for hearing House Bill 614. Abraham Lincoln once said, "Don't interfere with anything in the Constitution. That must be maintained, for it is the only safeguard of our liberties." I believe the same holds true for our New Hampshire Constitution. But what happens if your constitutional rights are violated? What happens if your freedom of speech is violated? A year ago, there was a local freedom of speech case that caught my attention, and I view it as a freedom of speech case. This case involved an Exeter High School student, a freshman on the football team, who was on the school bus and mentioned to his friends that he believed that there were only two genders. Another student overheard the conversation and argued the point, and even later texted that student who had made the original comment, and a brief argument ensued. The next day, that student who had overheard the comment contacted the athletic director and accused the freshman of, I quote, transphobic bullying. The principal and the AD were contacted and decided the freshman should be suspended from the football team for a period of time based on this bullying. The suspended freshman filed suit in Rockingham Superior Court. In court, the school officials argued that he was suspended for bullying and inappropriate language in the text conversation. The judge, as you'll see in some of the articles, did not buy their position and found them, and I quote, but he found for the school, and the reason is in this quote, which is from one of the articles: because New Hampshire law does not recognize a private cause of action for a political subdivision of a plaintiff's state constitutional rights, in the absence of bodily injury, property damage, personal injury, or statute, the court grants judgment to the defendants. That's the quote of the judge from his ruling. So the freshman walked out of court with the court finding his favor, but the law was against him. That's what called on me to file this legislation. As the judge found, he was suspended from the football team due to his beliefs and comments, freedom of speech. There was not a bodily damage or anything like that involved in the case, so the law did not provide any remedy for him. This was a case of speech. This simple legislation provides for any complete violation of a person's confidential rights, constitutional rights, the court shall provide relief as indicated in Roman 1 in the legislation beginning on line 9. And this is to be provided even if monetary damages are not alleged, as in the Exeter case. I think that this is important legislation because we need to defend our constitutional rights, and I don't think it's sufficient to say you only have a remedy for a violation of your rights if there's bodily damage or monetary issues involved with the case, such as a freedom of speech case. So I would hope that you would think about the quote that I began with Abraham Lincoln and the requirement that we protect our constitutional rights and our liberties and find favorably on this legislation. And I thank you very much for your time.
Are there any questions? Representative McFarland.
I'm sympathetic to the testimony. I'm not a lawyer, though, and so I would appreciate clarification of what is intended by lines 12 to 14.
I believe that there is a lawyer in the audience who has submitted a card, and I think he would have a better answer for you than I.
Thank you, Representative.
I am not a lawyer either.
Any other questions? Seeing none, thank you.
Thank you very much.
I only have one card, so if somebody else wants to speak, they can fill out a pink card. Sarah Burke Cohen, you have a pink card yet?
No, sorry.
Yeah, just fill one out there and turn it in.
Yeah.
Okay. All right. If you want to sit down, you can fill it out afterwards, and then you maybe help answer that question, and then we'll go from there. Thank you. You can just state your name so we can.
Ian Hewitt, attorney for Cornerstone, in support of House Bill 614. This bill, now full disclosure, by the way, I should say at the outset, I'm litigating the Exeter case that Representative Cordelli spoke about. So I was obviously happy when he told me he wanted to introduce this legislation, but the topic that's being addressed by this bill is much, much broader than anything that was raised in my case, including gender or even free speech. The problem that this bill addresses is that everyone agrees, all courts have held in New Hampshire, under our state constitution, if your rights are being violated on an ongoing basis, or there's a threatened future violation of your rights, everyone agrees you have a right to relief under our state constitution and our state courts, even if you just ignore the federal constitution. But if there's a completed violation of your rights in the past, no New Hampshire court has ever held that you have a right to any remedy whatsoever, even a nominal damages award for that violation. If it's a retrospective violation, you have no right to any retrospective remedy, not even nominal damages, not even declaratory damages. The court can't even say you win and you get nothing, no right to relief. So when Representative Cordelli told me he wanted to introduce this bill to address this, I was excited about it. But I will say that I definitely don't see this bill as any kind of rebuke to Judge Schulman's decision, the trial court judge in this case. I think he's a great jurist, actually. The opinion was largely favorable. And Judge Schulman was right to say no New Hampshire court has ever held that if you bring a New Hampshire constitutional suit, you have a right to retrospective relief. Now, that's all rights. That's not just free speech. That's free speech, right to bear arms, right to freedom of the press, any right. If it's in the past, you're not going to get relief unless you go into federal court under the federal constitution instead of going into our state courts. And this is something that this legislature can fix. If we want people in New Hampshire to be able to rely on our state courts, and we want New Hampshire to be independent, and we don't want Granite Staters to have to rely on and essentially be dictated to by what federal courts happen to say at that moment. So I actually have a case before the state Supreme Court right now where I have like a 50-page brief that basically is arguing the New Hampshire Constitution itself entitles you to retrospective relief if you look at the text or the history of the Constitution. But even if I win that, it is a good idea for the general court to have a statute addressing this, just like under federal constitutional law, you can bring a 14th Amendment suit, or if you don't bring a 14th Amendment suit, you can bring a Section 1983 suit under a statute that Congress passed in 1871. And they basically passed that to backstop our federal constitutional rights and make sure you have a remedy in court. And that is what the legislature would be doing by passing this law. So regardless of what you may think about what the framers of our state constitution intended, I would say if you just think about it logically and from a standpoint of basic fairness, it really just does not make sense. It's kind of a fluke to say you have a right to relief if there's a threatened future or an ongoing violation, but if it happened in the past, you have no right to relief. A right is a right. You should be entitled to some sort of remedy. And I would love to take any questions, but one thing I'll say is really any possible political objection I can think of to this bill, whether that's what about frivolous suits we have to deal with? How do we deal with the various official immunity claims? My answer to all those is going to be pretty simple, which is our courts already know exactly how to deal with all those questions under ongoing and prospective claims and under federal constitutional claims. They have an extensive body of case law that will analyze any one of those issues that I just raised. So just the last thing I'll note here is that New Hampshire has the second oldest continuously existing constitution in the Western world after Massachusetts. Our constitution goes back to 1784. And when our constitution was being passed, Granite Staters 3 times rejected in popular votes the constitution that was proposed to them because it didn't provide the people enough rights against the government. And the framers kept adding more and more rights until they had something that the people of New Hampshire were satisfied with. Our Constitution takes as its model John Adams' original Massachusetts Constitution, but if you compare the two, if you look at our Constitution and you look at Massachusetts's, you'll find Massachusetts's just sounds relatively weak. It's got the same rights, but our framers put a lot more kind of fanatical emphasis on those rights because they wanted to emphasize the government would be restrained, the people have strong rights, and we want to assure you, Granite Staters, of that so that you'll approve this Constitution. So I would say it especially doesn't make any sense in New Hampshire that we have this kind of historical fluke and oversight where if a violation is in the past, you have no right to relief. So I'd be happy to take any questions about anything.
Representative McFarland?
Thank you, Mr. Chairman. I'll just reiterate my prior question with a little bit more specificity. So if I understand you correctly, you're asserting in section 2 in rows 12 to 14 here, to the extent that you agree with the language, you're asserting that you already had this remedy under the Constitution and that this is also now being granted in this statute, and you already had this remedy in common law. And if I'm right about that, could you also please clarify how this would affect the ability to petition for redress of grievances to the General Court?
Representative, I think you have a pretty comprehensive understanding of the issues. I would just add one thing to what you said. Yes, that is part of why Section 2 is worded this way, but also our constitutional law in New Hampshire has a weird fluke, separate from what I've just talked about, that is not found in other states, where when you bring an Article 14 claim, our state Supreme Court actually, I don't think anyone else does this in the country. Some kinds of constitutional claims, when the court is deciding whether you have relief under the state constitution, they actually will look to state statutes to decide whether you have constitutional relief. So this isn't just kind of a way to say, you know, we disclaim the idea you don't have a constitutional remedy. It actually also could affect the outcome of cases. The last example of this most recently was Cater, Khater, that was in 2010. And basically what happens is the court says, if we will grant you a constitutional remedy under Article 14 in this quasi-equitable way if the general court has not granted you a statutory remedy. And the second part of your question, I don't see the only way in which it would, there could be a case that addressed the right to petition the general court is, the only thing I can think of, I'm just thinking on my feet here and spitballing. If, let's say your right to petition was denied for a long time, and then the general court eventually granted your right to petition, and so then maybe your prospective claim is moot, but you say, hey, but they unconstitutionally denied my right to petition for a year. So you don't have any prospective claim anymore, but let's say you say, I still want nominal damages, or at least declare that what they did was unconstitutional. Right now, that retrospective claim you don't have, because our courts would say, retrospective constitutional rights claims, no remedy. But now you would have one under this bill.
Thank you.
Yeah.
Any other questions? Representative Turer?
Yeah, thanks. Thanks for taking the question. I'm wondering, and I do not know this area of the law particularly well, is the difference between the future or current situation of having your rights violated versus what's being discussed in this bill, the idea that primarily that would be, and maybe I'm misusing the term, sort of injunctive relief, which says the court's going to stop your rights from being violated, whereas this seems to be awarding damages in a very different circumstance.
That is right, except that our courts have been very clear that they've never, as I think Judge Schulman accurately said in his opinion, there has never been any case in New Hampshire that says you have any retrospective right to relief. So this bill kind of pointedly doesn't even really take up directly the monetary damages question, and basically just says, look, you've got some sort of right to relief. Could be nominal, could be declaratory, could be some other equitable relief. But you're right, you have prospective injunctive relief if your constitutional rights are going to be violated in the future. But if they've been violated in the past, right now, not only can you not get monetary damages, you can't get anything under the state constitution. I should address the quote Representative Cordelli opened with from Judge Schulman's opinion. The reason that Judge Schulman spoke about bodily injury and things like that is you could bring a tort claim against a subdivision or against the state. So if a police officer beats you up illegally, let's say, you might bring a tort claim for bodily injury, but you couldn't say that police officer violated my state constitutional rights under A, B, or C provision of our state constitution. You would just have to rely on tort law, or you could, under the federal constitution, go into federal court, but people really should be able to remedy these claims in our state courts. Thank you.
Any other questions? Representative Manos?
Thank you, Mr. Chair, and thank you for taking my question. I'm really not clear on what specific remedy it is that you're seeking by way of this statute. That I get the nominal damages, but isn't a judge going to say, whatever the situation is, aside from Exeter, somebody's state constitutional rights were violated? The judge has to say that. Otherwise, there can't be any conclusion to the case. There can't be a judgment. So just the acknowledgement that somebody's rights were violated is, in fact, the remedy.
You raise a really good point, actually. And in old nominal damages cases from like the early 19th century, Justice Story on the U.S. Supreme Court said the idea that you can say someone's legal rights were violated, but they have no remedy whatsoever, not even nominal damages, that doesn't even make sense, he argued. You're just, it's incoherent, because if there is no remedy, we would typically say that really isn't a legal right. Maybe the government did something immoral, but they didn't violate your legal rights if you have no remedy. In this case, I mean, this is kind of an illustration of your question. The judge said, it seems like under the facts here that your rights were violated, that the school lied, etc. But regardless of any of that, you lose because it's a retrospective claim. So we don't even have the right really to declaratory judgment. We don't have the right to have the court say you win as long as it's a retrospective claim. The three kinds of remedies that are mentioned in here are, as you mentioned, nominal damages, declaratory relief. And one thing I'll comment on that I am inferring you're aware of based on your question is with respect to the other equitable relief clause. Already, actually, our state Supreme Courts under just general court statutes are courts of equity. So that other equitable relief clause in some ways is just kind of re-articulating the equitable jurisdiction our state superior courts already have. So you could interpret this bill as kind of just saying, the minimal possible relief that could remedy a retrospective violation, that's the relief you have.
Yeah, follow up.
Thank you. But there would have been a judgment entered in this case, correct? And it would have said A violated B's rights. And isn't the person or the entity that violated that person's rights put on notice not to repeat the behavior? And of course, if they do, then you can get declaratory relief and injunctive relief, etc., for prospective behavior or future behavior.
Well, they did win. The end of the opinion says that they won, and the statements from the school, in my case, for example, have been, we disagree with the judge saying our clients all lied, but we're glad we won, and they are right. They did win. And I would say, setting aside the facts of my case, in my appeal is just on the question presented of, does the New Hampshire Constitution afford retrospective relief for completed violations? We're not talking about gender or what the free speech test is or any of that stuff, because the judge really kind of decided all that stuff in our favor. So regardless of what you think about the judge's opinion in my case, under any future case, in the absence of something like this and or Supreme Court decision in my favor, the court's going to say anyone whose state constitutional rights were violated, you have no retrospective remedy.
Could I just ask one?
Yes, go ahead.
Would you be willing to provide us, and redacting if there are minors involved in the case, would you be willing to provide us with a copy of the court's opinion?
Absolutely. I'd be willing to provide you any documents, and they are already all redacted, so that'd be very easy. Thank you, Representative.
Any other questions? Seeing none, thank you.
Thank you.
Okay. Now Sarah Burke Cohen.
Good afternoon. My name is Sarah Burke Cohen. I represent the New Hampshire Municipal Association. The New Hampshire Municipal Association opposes this bill. It is vague and overly broad. This bill would allow plaintiffs to layer constitutional claims on top of existing statutory claims for which they already have a remedy. Currently, a violation of the state constitution will, in almost all cases, also be a violation of the federal constitution, so there is already a cause of action under 42 U.S.C. Section 1983. In the few instances where the state constitution provides broader rights than the federal constitution, there is almost certainly a state statute that already provides a remedy. In short, there are very few, if any, gaps where someone whose state constitutional rights are violated would not already have a claim under either federal or state law. This bill would allow zoning appeals, tax appeals, right to know complaints, and many other claims to be reframed as constitutional torts. For those who think I'm being an alarmist, please understand that lawyers have already tried in cases to do this. In one such case in 1986, the New Hampshire Supreme Court rejected the effort to turn a local road dispute into a constitutional claim. In that claim, Justice Souter wrote as follows: "We fear that provision of supplemental cause of action to provide an additional remedy in these circumstances would inevitably lead to the conversion of every road dispute in a constitutional tort action, which would carry a right to a jury trial separate from the layout of appeal. The likely multiplication of litigation resulting from a squabble would be too high a price to pay for such supplemental cause of action." In sum, this bill would open up the 43 articles of Part 1 of the New Hampshire Constitution and 101 articles in Part 2 of the New Hampshire Constitution, and allow layering of these constitutional claims on top of existing claims which already have a remedy, and create runaway litigation that would increase property taxes due to significantly increased legal expense for cities and towns. Therefore, NHMA opposes this bill, and I'm open to questions.
Any questions? Seeing none, thank you.
Thank you.
Is there anyone else that wants to speak on House Bill 614 that hasn't turned the pink card in? Seeing none, I'm going to close the hearing on House Bill 614. And that concludes our business thus far. I don't know if we want to discuss any more possible executive sessions or not. We can do that, but. $762 is an early bill, and that is the $30,000 to the judicial branch for the purpose of hiring.
No, the one where we're waiting.
Yep, thank you. Yep. Okay, we're going to open up an executive session on House Bill 746. And I recognize Representative Smith to make a motion.
Yes, Mr. Chair. I move ITL on 746.
Is there a second? Representative Turer, you want to speak to your motion?
I would. This bill was originally assigned to municipal and county and then transferred to judiciary. It was in the calendar with appropriate notice. There was no sponsor, either prime or other sponsor, who appeared. A member of the committee, out of courtesy, introduced the bill. There were no witnesses. There was no written material submitted to the committee. And therefore, the responsible thing, I believe, for the committee to do is to ITL the bill.
Representative Turer, you want to speak to your second? No? Any other discussion on the bill? Seeing none, I'll ask the clerk to call the roll.
Representative Tripp,
Yes.
clerk votes yes. Representative McFarland,
Yes.
Representative Morton,
Yes.
Representative Smith,
Yes?
Representative Page, Representative Manos,
Yes.
Representative Turer,
Yes.
Representative Rombo,
Yes.
and Chairman Mannion.
Yes.
10 yeas, 0 nays.
Okay, and I don't know if that's...
Mr. Chair, I assume this will go on consent?
Yes. No objection to that? None?
And I will write the report.
Thank you.
I'll really write the blurb, but I'll refer to it as the report.
All right. I think that's, I'll close the hearing of the executive session on House Bill 746. And if there's no other business, I don't know if there's anything else we can get done, but if you want to adjourn at this point, if we feel
I would
satisfied.
just like to point out to the committee that we will meet again as a committee next Wednesday. I would urge everyone to look at the bills that are on the calendar for next Wednesday. I know I'm entertaining, but I didn't think that entertaining. They are important bills. I leave to you to decide if that means that they are important to pass or important to defeat. But I really urge you to come prepared. And I think you will see what I mean when you look at the bills if you haven't yet had a chance to do so.
Yep.
Thank you for
I
letting
agree.
me.
Okay, if there's nothing else, we're adjourned.